Not 6 months.
Yes.
Plus, I'm permitted more motion question for roster of 31st court. The service matter when it was detected.
Tomorrow. Nothing.
The difficulty is tomorrow is the last day of the interview.
Tomorrow you can mention and make a request.
The interview of this department is not considered. Plus, I won't be able to apply for the associate. I'm the PhD doctor. Wherein the interview process.
No, what were you doing till 11th hour?
My department, I was waiting for the notification to be issued for the interviews of my department. My department has not.
When the notification?
So, interim order passed by this honorable court, wherein 31st court, wherein what has happened in that matter, the only job assistant professor has been stayed. But for associate professor as well, they are not conducting interviews.
When was what we are asking you? What were you doing? When were the interviews notified? Tomorrow you can mention. Nothing happens. Yes. Learn it 71. That's Learned Council for the. It is what? An appeal. Notice. So this is the continued phase. They have to move before the commission. They have only affirmed the order. We have only affirmed. They need a contempt petition, but yes, that will be referred. They don't have the power. We'll issue notice. This petition has been filed for non-compliance of the order dated 30th August 2022. Passed by the commercial court. Issue notice.
Lord, both the matters are identical. Item 1 and 2.
On what is leave petition? What is leave petition?
My lord, both are contempt petitions, my lord. Under sections 10 and 12.
Why leave to file? Notice on IA 1 of 23 and merit also. Yes. Next. Yes. Yes.
The CRP, Your Honor, against the order of the Honorable Commercial Court in IA number 90 of 23 for attachment before judgment, Your Honor. Your Honor, there is no prima facie case against me at all because there is a transaction between the respondent herein and some other company, and my role was only to supply the goods to the shipping yard, and there ends my role.
This is only a direction to furnish the security. It's not a case of attachment in that sense of the word, right? Order. It's not an order under strictly 38(2). You have been asked to furnish the security. And read para 11.
Yes. To furnish.
So you must have read it at home. So what does? So court has found that there is a prima facie case against you, and you are resisting this order means you want to sell the property and run away. That's the only thing.
No, it's not the case.
What else? I mean, you have been asked to furnish a security. And even that form of security has not been specified. It's not a solvent security or something like that. Absolutely no case for interference. Yes. This petition under Article 227 of the Constitution of India has been filed against an order dated 15 September 2023, passed by Commercial Court, by which application preferred by the respondent stroke plaintiff under Order 38 Rule 5 of the Code of Civil Procedure has been allowed.
Your Honor, I'm party
You
case.
don't want to study law, right? Is jumping into litigation. Which year?
Finished it, as of yesterday.
Oh,
FIDC.
examination finished.
Yes, sir. Yesterday.
Filed an application for enrollment.
Yes, Your Honor.
So first thing you should do is before entering the profession, this is not a theater or a cinema hall. Meet Advocate General. He will advise you how to appear before the court, right? Third on the question of admission. Admit notice.
I beg to appear.
You talk to Advocate General first. Mr. Prasad, please advise him.
It's a covered matter, my lords. Priority of the security aid, my lords, not registering of the sales certificate. May kindly order notice, my lords, 2 weeks.
Learn it. Citation.
Our High Court order, my lords, in WPA number 6628 of 2020 of the sales certificate.
6628.
May kindly order notice, my lords, 2 weeks.
Order dated.
17/8/2023.
Learned counsel for the petitioner submits that the controversy. Learned counsel for the petitioner submits that
I take notice for the first respondent, National Highways, to prevent illegal parking.
yes.
Fact, there are certain measures also there, like separate ways also there. No parking.
This petition has been registered on the basis of a communication.
I beg to appear for the respondents.
Mr. Advocate General.
My lord, 4 appeals, my lord, concerning a very prime property in Jubilee Hills area, my lord. So it is an absolute residential area, my lord. At the time, earlier, even now also. So in fact, my lord, the second round of litigation, the cause of action is altogether different in respect of the earlier adjudication. My lord, sir, the government, the Honorable Chief Minister, as then was, my lord, sir, has decided to allot 2 acres of land each in favor of 4, my lords, companies. My lords, the letter indicate that the decision of the Honorable Chief Minister then is subject to, my lords, ratification by the cabinet. My lords, I am only just replacing the earlier facts before your lordships. For kind consideration in respect of the cause of action, which has arisen subsequently, much water has flown after the decision, my lords, in respect of the allotment originally made. My lords, it is my duty to place before your lordships that the original allotment itself, which, my lords, though on a different aspect challenged before this court, which the matter attained finality after the Honorable Supreme Court. What was not brought to the notice of this court and the Honorable Supreme Court was it did not have the sanction of the cabinet. My lords, I am not arguing that, but I am placing that material fact before
You
your
have
lordship.
given a synopsis,
My lords, I have filed a.
date wise.
Yes,
We'll hear it after vacation, Mr. Sometime, on admission, after vacation,
Yes,
sometime.
as you are not.
Which date?
Well,
Subject to
exact
not-
Any date. After vacation, you tell us the date.
covered by a Supreme Court judgment.
But we will have to write facts, etc., right?
Well, if-
First round of litigation, this second one.
The
Complicate-
parties, between the parties matter.
Yes, we know.
In fact, a written synopsis, my lord, calling out entire facts have been placed for your lordship.
Give a this thing list of dates, right? What
Yes.
happened?
Right. It
We'll
is
give
already there on, but
30th October or whatever, 1st November, whatever you say.
1st November, your lordship may consider.
1st November, Mr. Srinivas. Yes, let mark the presence, let the appeal be listed.
The case
Yes.
where the Honorable High Court, my lord,
Ah.
at the first took cognizance of the fact that in the judgment rendered by Prakash Singh, my lord, the Honorable Supreme Court had directed. it states
So what is, have you seen what is the like?
the office objection says whether there is any public interest involved.
No. Non-compliance of an order, another public interest litigation can be filed.
But no, not like that. But actually, I have filed a public interest writ petition. The question before the registry is whether there is public interest in my case.
No. Question before that registry doesn't decide, that we decide whether or not.
That is my humble request before your lordship now.
No. What is the prayer? Please read it out if you have not read it.
I have read it.
Page 14.
Yes, my lord, I have read it.
So, read it for us. We have not read it.
Yes, my lord. But the reasons stated in the accompanying affidavit, the Honorable High Court may be pleased to issue writ direction or an order, more particularly one in the nature of writ of mandamus, declaring action of the first respondent, that is Chief Secretary, in not implementing the orders of this Honorable Court in CC number so and so as arbitrary and illegal. And
TC number means contempt petition, right?
yes, that's true. Well, what has happened was.
No. Read further.
Yes, so and so as arbitrary and illegal, and consequently impose exemplary costs and punish him for deliberately not implementing the orders of the Honorable Court in CC number so and so, and pass such other order or orders. But I'll have to explain a few facts, not then your lordship would take a decision. I'm bound by whatever it is. But
Of course you are bound.
yes, and there is no
Subject to Article 136, you are bound.
yes. The point is like this.
Yes.
You cannot quite very rightly
What,
put it.
like this?
So the case is like this.
Mr. What you have read it to?
Yeah.
What is registered in your mind by reading? This prayer clause. Just for sake of
the
read.
registry is of the view that I am in a way.
No.
Ah.
What is the, again read, it's not registering in your mind. What is the prayer which you have made?
But
Read
that-
it slowly, so that for the reasons stated in, read.
Accompanying affidavit, the Honorable Court may please to issue a writ direction in order, more particularly one in the nature of writ of mandamus, declaring the action of the first respondent, State Chief Secretary, in not implementing the orders of this Honorable Court in CC number so and so, that is already closed on a concession given by the learned advocate general.
No.
as
So
arbitrary
writ of mandamus does not lie for inaction. As we know about, when does the writ of mandamus lie?
But when the lower authorities are not following the
When there is a, you
statute.
know it, right?
Yes, obligation and
So
they have.
inaction doesn't lie, writ of mandamus.
But,
And then what you are trying to do, Mr. You are, since it is not registering, therefore we are telling you that
Yes.
this substance in this public interest litigation is to implement the order passed in contempt petition.
Yes,
So that is the question, that if an order passed in a contempt petition is not complied with, whether another petition can be filed or you should have some more, any other remedy.
well, unlike the other writ petitions, my lord, the public interest writ
You
petition
can
lies
do
in a
anything.
different plane altogether.
Yes, that's.
And the second
rules
thing
of
is,
pleading,
once an
etc.
order of the
No. So therefore lies in a different footing, and therefore rules of pleading, etc.
No,
doesn't
no,
apply.
I don't mean
you
that.
can do anything, whatever you feel like, because it's a public interest
I
litigation.
don't mean that way. My humble submission before this honorable court is, there is violence to the majesty of this honorable court. You give an undertaking to the court, you defy it, and you make the honorable court to believe that you are sincere in implementing.
Contempt petition. File a contempt petition. Another one. Public interest litigation.
The jurisdiction for contempt is 1 year, as your lordships are aware. Now we are in a very.
No, we are sorry to tell you it is not the correct position. This court has inherent powers under Article 215, for which there is no limitation prescribed.
It's true.
That is the problem. That is the problem with you.
Having been here, Mullard, on this side of the fence,
Oh,
what
that's
happens is, Mullard, one judge has one view.
You read
the other view.
read the judgment of Supreme Court in this thing, in the case of this thing, where the CJM of Nadiad in state of Gujarat was arrested.
Mullard, there is
And
also,
Supreme Court has written elaborate judgment on powers of this court under Article 215, which are in addition to the statutory provision under.
Courts Act 1971, I have agree with you. Well, there is also a line of judgment.
Don't agree. We don't need your certificate.
No. Well, there is also another line of judgments.
Don't say like this.
Well, there is another line of Mullard judgments
What other line?
which also say
So this
that
we are-
once the
this-
provisions
this-
of contempt of courts act are invoked, normally the courts will not.
No. So your reply is that since the period of 1 year has expired, therefore you have filed public interest litigation, right?
But
This is the answer
I am
to
just
this
an
query.
informant in a public interest writ petition.
Nothing.
The job of the
you have done your job. Now we will take care. Yes.
My humble submission
This
is this.
public-
Well, either way, I am not going to get benefited by
nothing.
the order passed by your lordship. My only humble submission before your lordship is that there is violence to the majesty of the court. The first officer of the court tells the court in a particular way to believe that they are sincere in implementing a particular directions of the honorable court and get the writ petition dismissed. Your lordship would see the other division bench order.
Nothing.
They have noted that they have issued a GO to implement the orders of the honorable court, but later, they did not constitute the committee properly. As a result, even today, the excesses of the police are not being adjudicated primarily before any authority. That's all, Mullah. There, my job is over.
Over.
As a public interest writ petition,
Thank you.
I bring to your lordship's kind notice, and I'm pretty sure that your lordship would protect the majesty of the court and pass appropriate orders. Even if it goes against me, also I am not bothered. That is not the issue at all. The question is about subserving a public interest in a public interest writ petition. Not maybe coinage is different and views are different, perspectives are different, and so much can be said. You have judgments this way, you have judgments there also.
No.
Where the judges have said,
You tell us that for this thing, for non-compliance of an order passed in a contempt petition, public interest litigation, which court has said? Because if we entertain the petition, we will be impliedly, holding that
Mulad, I thought
this
at
public
this
interest
stage your
litigation,
lordship would,
any case law, any research, or
I
just
will bring
like
it, if your lordship were, direct the registry to number it and place it.
No.
I will be
You
for
are-
your lordship such authorities which say that once you invoke the jurisdiction of the Contempt of Courts Act, you cannot press upon under Article 215. 215 would be used by your lordship.
No, that is not the argument. That is not the case here, whether 215 applies or not. We are on the issue whether for non-compliance of an order passed in contempt petition, a public interest litigation lies. That we are on that issue.
Your
Don't
lordship
divert.
may pass an order.
All right.
I'll
In
agree
this
with that.
public
But
interest litigation,
my
one
humble
of the
submission is-
petitioner has
my humble submission is
permit
the
us to
spirit-
pass an order.
The spirit
Permit-
of my action may be protected. That's all. I'm not
In this
a party not
petition-
personally interested in.
in this writ petition.
have the liberty to file a fresh contempt case. The lordship permits.
You file?
Yes.
We have said so. Yes, next. It should have done in the beginning itself. Yes.
I beg to repent, Mr. Raghuveer.
Huh?
It is not when.
Huh?
I beg to repent, Mr. Raghuveer, my lord,
Huh? Yes.
that it is a CRP filed against allowing by
Nothing wrong, mister. Like
Yeah.
technically you may be correct, but there's nothing wrong. It does not changes the cause of action. Nothing, no prejudice to defendant.
No, my lord. By the time of filing the suit, my lord, that company was not in existence.
Yes.
No pleading or nothing about any whisper about the non-existence or closing of the
Yes.
changing of the name is mentioned in the entire plaint. My lord. Entire plaint
Yes.
runs on Jade Solar Energy.
No prejudice, mister. No prejudice caused to you.
The amount
You are invoking supervisory jurisdiction of this court under
Yes.
every error of law we are not supposed to correct.
The reason-
Until unless it
Milord.
results, you may be technically correct.
It is not
Technically correct,
But I would like-
no prejudice. Better focus on contesting the suit on merits.
No. We alerted him, Millard, while cross-examination, he came to know about the mistake, Millard. In fact, Millard, I would like to take your lordship to page number 13, Millard.
Yes.
The cause of application, Millard, in para 4, Millard, I further submit that I thought that it would not be required. It would not be required to institute suit in the change name of the company as the
Page?
respondent page 13, Millard.
30.
Yes.
No,
His pleading,
what are you reading?
page para 4, Millard.
No, para 4 of what you are reading?
Para 4 of the petition, Millard. Petition file seeking correction of name, Millard. Amendment.
Affidavit.
No, Millard.
Para 4, I further
Page
submit.
number 13, Millard, 13.
Yes.
I thought it would not be required to institute.
No, I further submit.
Yes,
Yes.
submit. I thought it would not be required to institute the suit in the changed name of the company, Millard. It is his view, Millard. And the name, reason for changing is, Millard, it pays my para number 3, Millard. I further submit that due to the spiritual advice, Millard. He changed the name in the name of spiritual advice. And he think that it is not appropriate to institute a suit in the name.
He can change, right?
Millard, it is a body
According to you, it may be misconceived.
It
He
is a body corporate, Millard.
Ultimate test is, mister, we told you technically you may be correct, but no prejudice, right?
Millard, technically, Millard,
Fine.
we are not at fault, Millard. Actually,
Not at fault.
we are not at fault, Millard. And this allows it gives life to the suit, Millard, which is already dead, Millard.
Oh.
By a dead person.
Dead. Yes, that's it. Yes, mister. What? You are giving life to a dead person.
Well, that's also not correct. And only the name of the company has been changed. Company has not been wound up. The judgment of Calcutta High Court, company still stand exists under even under company's act continues to exist. Yes, fine.
Yes.
Millard, by
Yes, petition under Article 2. Anything else?
one. By just amending the trained, Millard, one should not give life to a litigation.
Live.
That's what my conclusion, Millard. And any mistake, Millard, by a corporate body cannot be excused in a simple way, Millard. The lower court, Millard, took much pains, Millard, in elaborately discussing about the things, and it totally favored the plaintiff, Millard, and it allowed the petition.
Identical case, but Supreme Court had allowed that. I'll pass on.
In this petition under with consent of parties matters heard.
in written statement, I have taken the particular objection. That was not considered, that was not looked into. At the fag end of the trial, my lord.
Fag end?
Yes, my lord.
PW1.
PW1, my lord. My lord, we have given, he was.
They have passed an order. Yes.
My lord, and before your lords, that your lords may consider some pleadings. And in this also, my lord, in this judgment also, my lord, it is a mistake done by advocate, my lord. Here it is not mistake done by, it is an affidavit given by the party, my lord, and it is a suit for recovery, my lord. Where, my lord, the cause of action and time is very important, my lord. If the amendment is sought after 4 years, my lord, that would boost the limitation, my lord, limitation for recovery, my lord. If that is considered, my lord, your lordship may once think about that, my lord, and your lordship may once again, my lord, the limitation is barred, my lord. By the time of amendment, my lord, there is no limitation. 3 years limitation is barred, my lord. That point, your lordship, my lord, I am hesitating about that. Not necessary.
We have passed an order.
Please.
Yes.
Madam, wait, please, your lordship. This matter, I am appearing for second respondent, my lord. The commissioner right filed, my lord, affidavit enclosing the, my lord, allotment list, my lord.
No, allotment list, Mr. The order was, you see, I mean, you don't even read this thing, right?
Page 4.
No, please see.
Furnish the
Madam.
date, my lord. Furnish the date. That is.
Please see the order. Presumably it was passed in your presence. Date of decision of representation, whether your affidavit discloses the date.
Yes, my lord.
Where have you said, which paragraph? Please tell us.
My lord, enclosed the list, my lord.
No, which paragraph have you said that the representation of the petitioner has been decided on this date? Where have you said?
My lord, I enclosed the list, my lord, at page 4, my lord.
What is the order?
That is true, my lord. The order date is there, my lord.
Again read, give it to him again.
I'm aware, my lord, that order, my lord, but I enclosed the list of allotment, my lord, made by the.
Again read it aloud. Probably we are getting it wrong. Please read it for our
I
benefit.
failed to mention the date.
So
in the
please,
affidavit, my lord. That is.
please read what is the order.
The third standing counsel appearing for respondent number 2 directed to disclose an affidavit on what date the representation dated 6/1/23 submitted by the appellant has been decided.
Where is the date in your affidavit?
That is
Not there. Learned counsel for the petitioner, Mr. So and so submits that even though failing which? But there is an order, right? He was disputing, that's why. There is nothing in your petition. You are surviving because of an interim order of the court, mister. There is nothing in your case, you know. Fine, yes.
as far as
We will decide it next date.
violation
Next.
of the treatment also.
But my seeker Paso,
Huh?
senior has joined on and Mr. Sitaramurthy has joined virtually, Morod. He has some connectivity issues. Morod is coming physically. You'll have to kindly pass to Morod, short pass over.
Matter can be heard after
Wait.
vacation.
Huh?
This matter can be heard after vacation because this is not covered by the order passed by my lord in the earlier.
All right. We thought so. We have recorded like that.
Yes, but
It
is not-
pass over.
it is not covered by my lord.
Our case is the
Last time also when the order was dictated, he entered and sought appearance. Today also adjournment. Today also is seeking adjournment. I don't want to argue what can be done.
pass over.
List after 6 weeks.
Your Lordship may pass.
Learned Council on 11/9/2023 also Learned. Hey, why you don't come prepared, right? You stand up only for this.
Sorry.
Yes.
time. May I please?
Ah.
Appearing of the count for the respondent, my lord, yes, having some personal occurrence could not make it today. Request for tomorrow or any other day. Respondent counsel, my lord,
No, no, you have to file. You don't want to file counter to this IA.
we're ready for to make a submission for.
All right, learned counsel for respondent prays for adjournment on the.
But I beg to appear. But the learned single judge has dismissed the writ petition on the two grounds. One, I have no losses, and second, there is a disputed question of facts. But both are incumbent from the fact itself.
Oh, yes. How much is the delay?
67 days delay.
All right. Heard on the learned senior counsel for.
But my friend is there who's taking care.
Last date he demanded copy. Today is not saying anything, your friend. We remember last date he demanded copy from you and sought adjournment. So
That one is a copy.
then what is this? It has to go back to single judge. There's no point in keeping the petition. Mr. He is aggrieved in the sense that the amount due to him won't be paid without approval of ED. How can?
The aspect which I had submitted before the learned second judge also is that the quantification of liability has to be done and the claim.
Whatever. How can he say that you are not a party to the communication, therefore you have no locus? We don't think you can support this.
What you also consider is that an application has been made for appointment of an arbitrator which is already pending before this honorable court.
Only thing is, the dispute between me is an arbitrary dispute which is already pending. Your lordship may come to page number 72, madam.
Oh. No, that's correct. But
it has to, what your lordship said, it has to go back, the learned judge has to adjudicate on merit.
Merits. What do you say? Correct. It can't be dismissed like that he has no locus. Yes, madam, mark the presence. There's no point in keeping it pending here.
Very well.
Heard on IA number so and so. Which is the IA? 16. Heard on IA number 1.
I have filed the counter affidavit in the
Counter affidavit.
See that, my lord, the section, my lord, the first respondent had filed the writ petition seeking a limited direction, my lords, which is to hold the elections for a recognized trade union. This writ was filed, my lords, under a code of discipline, which has already been held, my lords, in a series of judgments of this honorable court to be non-statutory and therefore not enforceable. But without, my lords, taking that technical position, elections need to be held. Therefore, my lords, an earlier direction was issued by the learned single judge to hold the election by October. What happened in the interregnum is, my lords, that the election commission has notified, my lords, the assembly elections for the state of Telangana now to be held, my lords, on 30th November. And this is an election, my lords, that involves 6 districts. The entire state, my lords, machinery is required for this election because it includes a coal belt in which, my lords, there are a number of Naxal areas as well that are involved. Therefore, my lords, the appellant company, as also the state of Telangana, moved the learned single judge seeking a reasonable extension, saying that the election can be held, my lords, instead of October, within, say, 4 weeks after the election, which would mean, my lords, instead of October, it would be held, my lords, by the end of December. Both those applications were filed before the learned single judge. 13 out of the 15 trade unions, I must tell your lordships this, there are 15 trade unions in the appellant company. 13 out of the 15 at page 49 have, my lords, given letters to the returning officer R4 requesting that the elections be deferred till the assembly elections are held because they have their own political allegiances and involvement in the election. My lords, disregarding that, by the impugned order, my lords, the learned single judge has refused the extension, and therefore we are before your lordships. I have, my lords, placed before my lords the application filed by the state as well. Page.
We believe that they are not contesting your prayer, right? So
Till the last date they were.
but probably.
IA number 3 of 2023, not passed by the honorable court.
No, but see, Mr. The elections have to be held.
We are bound by the orders of this honorable court.
No, government. Therefore, we are asking you what is your elections have to be held. You yourself have said in this thing, your counter earlier filed to some IA that the returning officer had proceeded and in fact was about to notify the dates or something like that.
Also already fixed your page number 100.
Okay. See, yes, Mr. He should tell us.
So, my lord, I'm feeling my learned friend, my letter before the learned single judge.
My difficulty is I am bound by the orders passed by the in IA number 3 of 2023, page number 56. That's the reality.
50.
The earlier order, which said what
that they have been in pursuance of in compliance of that orders only. Rakshapa kindly see page 156.
Yes.
Last minute, taking into consideration of overall situation, this court is of the opinion that election passes may be deferred to 1/9/2023. Page number
All right. So
53.
thereafter they sought the extension of.
Now, my lord, the counter statement filed by me, my lord, just now, my lord, in the
Yes.
my lord, page number, my lord, 9, page number 9, my lord. No, just now, my lord, given the today.
Just now, this one.
This was meeting held on 22/9/2023. And wherein 15 unions are present.
Yes.
15 unions are present. The
No, Mr. That all we will see. But what is like the elections? The 2 state assembly have been notified. They are to be held on.
Now, page number 17. Page number 17, last page.
What?
The schedule of election is already fixed. In compliance of the orders passed by IA number 3 of 2023, the schedule already fixed. We are proceeding.
No, that's correct. But majority of the stakeholders are making a request.
No. With all due respect, no. Because
the state government 13 out of the 15.
That's why
No, Mr.
I have no personal interest because only.
So supposing if we modify the date, you will hold election. Correct, right? That's it.
That's all.
Yes, yes.
Union
So when, Mr.
One start of the other
You
union.
tell in the month of December,
The other unions.
December, my lords, is the date for declaration of results. Therefore, within 4 to 6 weeks thereafter, my lords,
By end of December, my lord, last week of December, my lord, counting would be taking place on 3rd of December. My lord, thereafter, at least these authorities, my lord, it have at least 3 weeks time, my lord.
Now, my lord,
That's a bit maybe high. In the last week of December, my lord, we are.
as per the schedule, my lord, nominations are there, they are submitting. But some of the unions, my lord, they issue notice of contempt. You will be under contempt if you not proceed with the schedule of election. But in the year number 3, we are bound. That is only our.
So we are modifying that. You don't dispute that this court can modify.
before that one
What,
submission.
how can you be held liable for contempt if we say,
Model
then
code of
we say,
conduct has come into force.
you have to be practical, Mr. What like, I mean, this election involves, correct, like 6 districts. 6 districts. And Naxal areas also as pointed out by Lalit.
13 assembly constituencies, my lord.
Now there is no answer.
So then, so what, you hold it in this thing last week of December?
Subject permission.
What, you find out what are restrictions.
Before that, my lord, permit me once you.
Major stakeholders like the majority of the stakeholders. And this thing.
So in fact, a non-statutory election, my lord.
Exactly, that is.
It's a
Neither.
I don't know why Mr. Praveen Kumar is so much interested in.
No, I am only, interested only to comply with the orders passed.
Yes, yes.
Nothing beyond that.
Nothing.
Nothing beyond that. Only IFC is only coming with it. Otherwise, I'll be under contempt.
Yes.
My instructions are any day. To last minute.
Yes, yes. After this
I
thing.
appear for the respondents.
Yes. Oh.
At our,
Yes.
at our instance, the elections have been initiated. For the last 2 years, we have been pursuing to conduct the elections. And ultimately, the election has now been notified. You'll also see page 100.
So you are one of the trade unions, right?
Yes, sir.
I am the writ petitioner who filed the writ petition.
That give that. 18. No, there is one counter filed by yesterday. I saw, read it. You earlier you had filed a counter to IA, some IA, no? Give it details. No, yesterday I have read it.
Yes, yes, yes.
Give it.
But page 100 minute is the schedule is given.
1 minute, one. Give us one. Not this. He has given some facts there.
Maybe give your lordships a 1-page note. My lord. It's
Yes.
so great. Awesome.
Yes, Mr. So see, now you must be aware about the subsequent developments, what has happened. Right?
Yes, sir. Now the election is now notified. November is the election schedule starts. Whereas in this case, elections are scheduled on 28th October. By that date, everything will be over. Page 100, you may see the schedule given by the Deputy Labour Commissioner.
No, but we are, Mr. We have been told by Learned Counsel for the appellant and other respondents that 13 out of 15 trade unions have made a request for the election. Like, I mean, we are given to understand that majority of the stakeholders want the election, including the government. Like they want it to be end some week off, and we believe state government has a role to play.
Yes. I let
Yesterday,
law and order and all.
Please.
may I make one
Machinery
submission?
has
Minute?
conducted. Reporting agents.
Day before yesterday,
There are
13 unions have submitted their. Day before yesterday, 13 unions have submitted their vote symbols, and they were given the symbols also. They participated in the process. It is not that the 13 unions have not participated.
They are doing
a proper statement as on today.
just to avoid disqualification.
Yes.
Avoid disqualification.
1 minute. So
No minute. And the meeting scheduled to be held last 2 days back, 13 unions have participated. They have taken the symbols allotted by the election officer and they gave a consent for conducting the elections. 13 unions have given. There is a proceedings also made. I think the learned Solicitor General would have passed on to your lordships.
Manishwar, these are the proceedings. These are the letters.
13 unions have participated.
Let's see what they say.
We'll hear him then.
I'm sorry.
Yes. Yes.
13 unions have participated and they have taken the symbols allotted to them. Every union leader have signed on behalf of their respective unions. Therefore, it is not correct to state that 13 unions have given consent not to participate in the elections. Right? It is the now modus operandi seems to be of the Singer and Nicholas company to project these issues. In fact, they have given a consent as early as 2022 that we want to conduct the elections. They gave a letter to the Deputy Labour Commissioner Central. Then only the election process has
What is the election schedule which has been notified? What is the election?
Page 100, page 100 of the writ appeal papers.
Page 100. That's what I read. In the counter also I filed it. Last page. Page 17.
Yes.
Except for the election date, where the officers are required to appear, there is no role by the state government or the election missionary. Except on 28th October 2023, where the polling will be held. There is no other requirement of a state missionary for
when it was notified,
conducting these elections.
Where it was notified?
27/9.
17/9.
Page 100 minute.
Yes.
In the meeting held on 27/9, that is page 95. It starts.
Yes. May I point out?
Yes. Yes, Mr.
Therefore,
according to you, only polling is required to be held now on 28/10. And
there is no requirement of election missionary to participate at any other proceeding except on 28th. There should be a elections held.
So if the government says, then we will think about that it can provide.
No, it come here.
That's all.
Collector.
But the government cannot now say that this is an election connected to the state elections, and they make a letter saying that we will conduct after the parliament elections. But that is how they are trying to project from 2022 onwards.
But the difficulty, they did not so far submitted voter list. Voter list has been submitted as per the schedule on 3/10 and on 30th/9. So far, we have not submitted the voter list. And as per the schedule, nominations have been submitted filed around 14 unions on 6 and 7 of this month. 6 and 7 of October. Nominations are filed. Nominations by the 14 unions have been filed. Whereas voter list has been so far not submitted. By a Singer and
Yes.
Lords, R4 is only, my lords, acting per the directions of this honorable court. Please see IA 6 at page 428.
if I may, my lords, which is the application.
1 minute, provided. Yes, Mr. Vidyasagar, anything else?
Therefore, now even the postal ballot, it's a voter list is only for the purpose of identifying the voters. Postal ballots. That is what is specified in the paragraph.
So therefore you are saying that now everything election schedule is notified, everything is done,
Yes,
there's question of extending.
Yes, sir.
Yes, but you say.
Yes, sir.
Anything else?
Yes, sir. Yes, sir.
Yes. Yes, Mr.
My lord, please see page 428. It is IA6 filed by the state, my lords, also seeking an extension of time. The prayer is at 429, my lord. For the reasons stated in the accompanying affidavit, it is prayed that this honorable court may be pleased to direct R to R5 and R8 to process verification of the majority union through secret ballot elections in the establishment of Messrs. Singareddy Collieries after the General Assembly elections are completed in the state of Telangana and consequently modify the interim order dated 23/6/23.
What are the reasons?
Reasons are at page 436 onwards. It is para 5 notes. It is respectfully submitted that the Election Commission has issued schedule of second specially summary revision of electoral roll with reference to 1/10/23 as the qualifying date for Telangana. The detailed schedule, my lords, is set out there. Then please see at 437. Further, it is to submit that during this period of claims and objections, that is 60,335 claims received for inclusion, deletion, and modification in the voters list. All the Revenue, Child and Women Welfare Department, Panchayat Raj and municipal employees in the capacity of booth level officers, booth level supervisors, assistant registration electoral officers, electoral registration officers have been involved in the verification of these claims. Since it is a continuous updation of electoral rolls, many more claims will be received which require to be disposed individually because of the impending assembly elections. Further, it is to submit that the Election Commission has issued instructions via memo dated so and so for organizing sweep activities in the district to increase the voter participation. This activity is also attended by the employees stated supra. It is further submitted that the EC has given instructions for preparations of arrangements at polling stations, that is basic minimum facilities, etc., my lords. Then video surveillance, video viewing over the page. Therefore, my lords, at para 6, it is respectfully submitted that as I am being the district election officer and controller of Adra 3 Kothagudem wide letter dated so and so, addressed to the Deputy CLC, that is R4, and copy to the letter so and so, informing that the police personnel, revenue, Panchayat Raj, and municipal employees will be engaged in the Ganesha festival, followed by immersion from so and so. Further, the Dasara festival, which falls on 15/10 to 24th October, the above staff also are required to look after the law and order situation. And that is the request made by them. The letters, my lords, of the 13 trade unions are at page 459. 13 out of 15 trade unions, my lords.
That is on account of Ganesh Himachal.
459. I'll read just one, my lords. The first one is by the recognized trade union, that is R6 to R4. In this regard, we submit that our unions stand in the matters detailed hereunder. Ours is a politically affiliated trade union in the ensuing general elections to the Legislative Assembly of Telangana, for which the Election Commission is likely to announce the schedule shortly, and majority of our union members will be involved in election campaigning in their respective constituency. As such, it will be difficult for our union to concentrate our canvass in the elections to the trade unions and SCCL. Further, already on our request, the management of SCCL has issued instructions to field authorities to treat all unions equally, my lords, and the issues related to the employees as represented by our union are being addressed properly by the management, and we express our faith in the management of SCCL. There is already shortage of coal across the country. Further, the rescue and safety competitions have already been scheduled for the month of October. Since the issue of the term of elections is pending before the Honorable High Court, the elections may be conducted after the outcome, my lords. For the reasons stated above, we request you to consider and conduct verification of membership in SCCL after the completion of the ensuing general elections to the Legislative Assembly. And 13 such letters are given.
my esteemed friend, Lord Mr. Vidyasagar submitted that the 13 unions now participated subsequently. Just see the letters that we have now furnished to your lordships. This is what they say on 6/10/2023. After, my lords, they filed their nomination. I just passed on to your lordships, Lord. I'm sorry. It's a recent document. 6/10/2023 set of letters, my lords. I'm sorry, it should have been filed perhaps with an application. These are, my lords, the letters written by these 13 unions again to the R4. The reference is to the OM of 5/10/23. In this connection, we wish to inform that on 27/9/23, we have requested your authority to adjourn the meeting and not to draw the election schedule. Your authority has drawn the election schedule for trade union elections on 27/9/23 in our absence. In order to avoid disqualification from participation in the elections, we have filed our nominations. It does not mean that we are willing for the union elections as per the election schedule drawn by you for 27/9/23. In view of the above, we request you again to reschedule the elections after completion of the ensuing general elections to the Telangana Legislative Assembly. This is their position. And once there is really no overwhelming public interest in conducting this, when there is a state election to be held, I may just conclude by showing your lordships one order of this honorable court, though lords of a learned single judge, which is at page 553, where this very code of discipline, I don't want to be technical, but has been held, my lords, to be in fact not enforceable in a writ. In fairness, yes, my lords, if union elections are held, it's healthy. But that doesn't mean, my lords, it can be thrust upon all parties at such a time. That order, my lords, is at page 553. And the limited request, therefore, was to extend it instead of October, my lords, to the end of December. And there's no grievance that any union, my lords, has been treated with any discrimination or otherwise. They're all treated, my lords, equally. There is not a single grievance regarding any settlement.
No, but nomination papers, etc., have been filed,
Yes.
even though under protest, right?
It's right, not on 6th and 7th of October.
So maybe the date of poll can be altered and remaining process remains as it is.
Lords, other than the nomination, there is nothing else that has happened. Now, my lords, the entire canvassing, etc., that has to take place in these districts. There is a sensitivity there. Not then, I mean, I don't hold a brief for the state, but the state will be, my lords, in a piquant situation. Your officers will, the code of conduct has now, my lords, been triggered after the notification for the state. Then, my lord, the entire bandobast in those areas will have to be made by the state, my lords. That's the larger difficulty. If 4 weeks, my lords, later the election is held, there's really no prejudice.
No, that's what we were wondering, that we could only alter the date of polling only. The rest, everything else has been done, right?
Important aspect I would like to bring to your lordship's notice is that
Yes.
they conduct election with what electrodes? I posing question to myself.
Huh?
As of now, electoral rolls have not been prepared by the management. And in view of the general elections fast approaching, my lord, our officer has been on the duty for enumeration of the electoral rolls for the general elections for past 3 months. Election Commission had been chasing us, our officers, to do this and do that. And that's why I made my request before the Leonard single judge. In view of the urgency that we are committed to conduct electoral rolls, therefore this election may be deferred. Your lordship may kindly see at page number 450, my lord, the collector of the Bhadradri and SP of Bhadradri of concerned district collectors, I would be exhorting them to defer the elections because their officers are busy with the enumeration of the electoral rolls for the general elections fast approaching. But
General election means what?
General elections of state assembly.
State assembly.
Yes.
But you don't postpone it to 24 election, right? Yeah.
No, there was even that letter, my lord, in fact.
Your lordship may
The
please
letter they have given.
Your lordship may please to fix a date in the month of December. I make my statement before this honorable court. By all fair or foul means, I will conduct election. I will permit officers to attend the election duty in the month of December, fourth week, my lord. Your lordship may kindly see page number 450, my lord, how the collectors and SPs have reacted to the contemplated schedule that would be issued by them. My lord, it's page number 450.
So which, when you said last week of December?
Yes. Let
Third week.
management prepare voter list.
May I make
Of the free and fair election.
No, additional advocate general has given an undertaking that it will provide all assistance on a date which may be third week of December.
Milady, earlier also he has given the same undertaking twice.
This is an undertaking on behalf of the government that they will do it.
Yes, milady, earlier also they have given the similar undertaking, knowing well that the elections are scheduled to be.
I was argued.
before November 20.
1 minute. Yes.
Elections are scheduled to be, election notification is likely to come in November 2023. Therefore, let the elections be held in the October. That is the
Undertaking on
undertaking they
behalf
have
of
given
the
before
government
the
that they
London
will do
Single
it.
Judge. Yes, but earlier also they have given the similar undertaking, knowing well that elections 111 elections
I
will
was
be
argued.
concluded. November 20 it will not come in the general elections for the assembly.
I was argued.
November 20, now general elections are due in December. Then they say
General election in November, 20th November.
May-
20th November and 3rd December. This thing he says that by 7th December the new government will be sworn in. He knows the date of swearing in also.
This election may be different.
So he says that they are after any date and they are giving an undertaking.
Then the elections will be notified for the panchayat and municipal elections in December and January. Then in June, March, general elections for the parliament. That is the reason they refer to at page 455.
No, Mr. But how do the problem is that the dates of assembly elections have been notified. That is 30th November. So this thing now stand. They are unable to provide the assistance without this thing participation. You will agree that it can't be held. Who will be responsible for law and order situation if it happens? Definitely not your clients. Will they maintain law and order? You give an undertaking that we will maintain all across 6 districts and we will ensure that election is held in a peaceful manner. How their involvement is necessary. It's not that we, at the instance of the management, we want to postpone. The free and fair election have to be held.
Yes,
There can't be any dispute. The only thing is practical difficulty.
Right.
You have heard Mr. Vidyasagar's this thing additional AG saying you again.
Yes, sir. Yes, there is a repetition which they have been coming from last 2022 onwards. Not now. For last 1.5 years, it very same.
Mr. This violation of undertaking. I mean, he understands what are the consequences.
My friend is distorting the fact, my lord, with great respect. What I was submitted before the learned secretary, there is every possibility because of
his apprehension is you will conduct. No. This thing is that you later on you will say local body. Then you will say that general election.
Never I say, my lord, I will persuade the government not to restrict that. I will persuade the government.
There is a letter speaking from the government. Letter on record, page 455, you may see. Page 455, you may see there is a letter on record that I will conduct after the parliament elections in 2024.
No, they are saying
before this honorable court.
They are saying now we are issuing a direction, right?
Yes.
And according their undertaking, will not their stand maybe this thing. We are not giving them liberty to do it after parliamentary elections. They are directing.
Similar undertaking is given before the learned single judge twice, and it was adjourned. Right? There should be. But I give it to your worship.
No undertaking so far had been given to learned single judge. What I was submitting the fact, I didn't give. Let my learned friend say where learned single judge made an observation that I gave an undertaking.
I will persuade the government want to confront with the facts, but I will refer to that order of the learned single judge where his undertaking is recorded.
I submitted, not.
Page 56. Page 56.
And 57.
Page 56 minutes. It starts at page 55.
How?
This is the undertaking given by the learned additional advocate general. Now we can't say that I have not given undertaking, I made submissions.
Page
55 minutes. 55.
55. Yes.
56, sir.
56. The learned additional advocate general has further submitted that on such requisition by the returning officer, several district collectors have expressed their inability to adhere to the election schedule proposed by the returning officer. Citing several reasons, inter alia, it was stated that enumeration of voters for the general elections to state legislative assembly to be held in the year 2023 has commenced, and the entire state machinery and officers of several departments are being trained for ensuing general elections, and their services are being drafted for election duties, and some of the district collectors have also stated that the special arrangements need to be made, as some areas of Single Entity Colonies Company Limited come under within the having influence of Maoist extremists, and requested this court to defer the election process to be commenced from 1/10/2023, so that all the process relating to upcoming general elections would be completed by them. The request of the land single judge was opposed so and so, so and so. So it was their undertaking that we will conduct by 1/10, commence from 1/10/2023.
However, not been with the great respect, cannot be an undertaking.
It was made it
The same situation, my lord, the assembly elections, I requested the honorable single judge. That same situation, still assembly elections have not been conducted, which are fast approaching now as per the notification given by the election commission on 9th of this month. Still that condition is not completed, my lord. Still elections have not been held for assembly. What I submitted before the learned single judge, in view of the general elections for the state assembly, this may be deferred. That is what I submitted, my lord. It cannot be an undertaking. My unfinished, I cannot say that is distorting.
No. This, so Mr.
and
Therefore, their undertakings will not be of any purpose. They will go on making similar. They made another representations. They made another request. Their undertaking, their submissions will conduct later. And page 455, they say that we'll conduct after the general elections of parliament in 2024. That is the letter they have addressed to the returning officer.
May I make a humble submission? Lordships Lords, grant time till the end of December. Call for the undertaking, keep the writ appeal on your Lordship's file and have it in the first week of January.
No purpose
Even if
would
there
be.
is not an iota of disobedience of that undertaking, I think we all know, my lords, what consequences could follow.
Yes, I do hereby admit the statement of the letter proceeded, but I give an undertaking by a form of affidavit by letter. Your lordship may grant. Meanwhile, this may be deferred.
So when will you file the undertaking in the form of affidavit?
Today itself.
Today?
Yes.
Who will file? Who will file the affidavit?
DC.
We will record this. Who will file the affidavit?
Director of the company will file the letter.
No, my lord.
Director of the company, why?
Coming in the way.
Officer of the government, Mister, what is this? Director of the company.
State of Telangana Energy Department profile. The respondent will file chapter.
8th respondent.
The secretary to the Energy Department. Under
Secretary. Today.
Today.
Huh?
Tomorrow. So because secretary is
tomorrow shall
busy
be-
with the election process.
What is Secretary Energy? So what? So he will file an affidavit tomorrow. We are recording. Right?
And that's me kindly the schedule, my lord, where it stopped, not that only, my lord, I will abide by your lord's directions.
Schedule.
Not schedule, my lord, is already fixed, my lord. Where it stops, my lord, the nominations are already received. And my lord, the voter.
From that stage, it will be carried forward, right?
Please, we will.
From the stage of nomination.
And my lord, let them survey.
Nomination is from the stage of nomination, it will be carried forward. You will notify now a date in consultation with the government in tentatively in 3rd week of December. Right?
Let them furnish, my lord.
Within 1 week.
Voter list also, my lord, priorly, my lord.
So voter list will be furnished by Mr. Around
It's direct. I just felt not since there are periodical retirements that take place and there are 43,000 such workers closer to the date of election, but I'm in your lordship's hands.
how much time do you need like, by what time you need the polling, this thing, the voters list?
By the end of November, my lords, if your lordships. Sir, you get something.
Already notified, not after the furnishing of the voter list, not will proceed.
No, if it's, is it all right if they furnish by 30th November?
Not normal attack.
No, not will.
30th November voter list they will furnish, thereafter you will, no, but you can notify, right? The election within 1 week, date of polling. Within 1 week from today?
Please, and that date, your lordships are keeping it in the end of December.
Yes, sir. Third week, sometime in third week.
Please, third week, okay.
Mister, you tell, we will say in the order. You see, third week. We will say in the order why to then again give rise to another round of contempt.
We are ready.
He is extremely busy.
Normally in the schedule already issued, they have deleted.
No, what we are saying is, Mr. This stage of filing of nomination form is over. From that stage onwards, they will only furnish a voter list.
Yes.
And then date of polling, that's all.
Yes, we will.
That can be notified today also.
We will provide all the state officers to cooperate with the elections.
Yes. You have to cooperate.
Yes.
So, what date? Mr. Praveen Kumar, tell us a date.
Third week last minute.
What date?
Nomination.
Third week of December, date. Give madam.
22nd December.
22nd December. 22nd is a Friday.
Yes, Friday.
Sir, you please.
Yes. 22nd December.
And we will keep it pending. It will come up on 27th or 28th October and December.
I'm told the 23rd December is the Singareni day of the appellate. So if it could be a day after 23rd, Manoj, instead of 22nd, maybe on 26th. Just a humble request.
26th seems to be a holiday. What something?
Not 27th.
27th.
Please, so great.
We will have it then on this petition on 29th.
Please.
So there is no winter vacation here. So we work.
Let's realize, Manoj.
Yes. So hopefully you will not be required to come on that day.
I hope not.
They will only tell that elections have already been held.
Report compliance to your lordship.
Right, Mr. 29th December.
And prior to that, we will resume furnish.
30th November. They will furnish the voter list.
Yes.
So, Mr. Under this, the code of conduct is non-statutory, right?
Yes.
The code of discipline.
Discipline.
Yes, yes.
Is non-statutory. And we can expand the time between the date of filing of nominations and this polling, right?
Quite so.
There's no time limit prescribed.
In fact, there's no time prescribed for an election. It only says the term shall be 2 years. So that's.
All right.
Let them cooperate with the party.
Of course. Yes. You have to cooperate.
Not, sir. Otherwise, your lordships make it part of the order first.
Yes.
But I have filed with another IA, not seeking a London support not to extend the cooperation.
Yes. We will record this thing like
What's the
their undertaking also along with additional advantages.
the officer is present?
Yes. So we'll.
given your lordship. So one page. note.
Yes. Yes. Mark the presence.
Scrutiny also may not result done, but symbols also may not get. Symbols also may not allotted.
Allotted then. From the stage, from the stage of allotment of symbols.
But may please.
You will be there on 29 December. You hope so, right? We are, no, but you have given an undertaking, so we will.
Lordships are deprived of a vacation.
Yes. Tell them, yes.
So,
But may please.
Lord, I am appearing for the respondents, Lord, 4 to 6 in this matter. Lord, I request 4 weeks time to file counter in this matter.
Well, earlier also not 3 occasions, not time was not taken by the other side. Counter.
Let them file, learn and, Mr. 3 weeks already granted, right?
Right.
I received
Learned
report.
counsel for.
Finally,
Because they are not paying the salaries to the petitioner.
Huh?
They are not paying the salary to the petitioner.
Why?
But they are not paying money since last more than 1 year.
Salary?
Yes.
Why?
in fact, he did not join the post, Lord. Though he reported after that.
File counter to
Yes,
this also. He is
that
not getting
there is a
salary. How will he survive?
Well, let them pay the salary.
In the remarks.
So are you working?
Yes, because I joined duties.
No, it's not. I received the instructions, Lord, for filing counter.
File a counter list.
That is what.
Yes. Learned counsel for the petitioner submits that the yes.
Request 1 week time. 19 and 20. Senior counsel is engaging.
You what? Senior counsel for a statement of loan account.
Yes.
You want, all you want is a loan account, right?
Lordship, the petitioner is regularly paying the installments. And
Also, we don't have a degree in CA course. We can't maintain and find out with what is the monthly amount, how much you are paying, what is the due, what is quarterly rest, how it is computed.
that's what the respondent.
We don't maintain.
The respondent, they are not furnishing the reports. Even multiple requests.
You supply a copy, there must be a counsel, and if that is statement is found to be incorrect, we will, Mr. Apart from this, you will face the music. Is there a counsel for Kotak Mahindra Bank?
Yeah.
Who is the? Who is the counsel? You said yes.
There might be.
Might be. We don't know, Mr. This all tactics, right? You have taken loan, you don't want to repay and somehow file petition. And why this petition should be entertained, Mr. You had filed, this is your second petition, right?
Yeah. We are regular.
1 minute. This is your second petition. Earlier you had filed a petition and sought stay. We told you to go to DRT. You didn't go to DRT, again filing a petition. This is extraordinary discretionary jurisdiction under Article 226. That means the attempt is to keep the matter sub judice, not to pay the amount of loan and seek an interim order and enjoy life. Right? We will not permit this conduct is this thing. Why you did not approach the DRT when despite liberty being granted to you in earlier petition? Tell us any explanation. And this also 3.8 also you did not ever appear. So attempt is to keep this writ petition pending. You did not appear on 3.8. We adjourned it. Today you are saying that 1 week because of this thing. Where is the order? Get the order passed in WP 22070 of 2020. 10/11/20. Double 2070. WP, get the order. 22070/2020. So why you did not file? We will dismiss this petition.
Doesn't file.
Hey, you are a borrower, 3 crore 65 lakhs, not repaying and filing petitions. He has funds to file petition, but not to pay it to the bank. He should have done well. Whatever he has paid fee to you, he should have paid to the bank.
Your Lordship,
Instead of funding you by for filing.
Your Lordship, almost 5 crores have been paid.
Nothing. We don't know. We don't maintain any account. High Court doesn't not maintain any account which borrower has paid what.
That's what we are begging.
No, we are
For the account statement only.
nothing.
They are not furnishing.
Why you did not go to DRT and why have you filed this petition? Tell us. This is Mr. Just like your previous writ petition, you had obtained a stay and kept it pending. We dismissed it. Then we asked you to go to DRT. You have not gone to DRT. Again filed a petition. Where is the application made to the bank to supply this thing? He will go somewhere else, Mr. Stop. This is serious matter. No, this all regulars.
Page number 29.
This is 18. Huh?
Lordship, page number 29.
This was filed when?
Continuous request letters.
No. When have you? This was filed when?
In 2018.
So 5 years have passed. What were you doing since then? If they did not supply, we could have understood that you would have filed a petition in the month of May that, sir, they are not giving me.
We are continuously requesting. In 2020 also we have requested. 2022 also we have requested. Page number 39.
Hello. Council, you can even check online.
This all
These days you can check online about your account status.
Even that also they have not.
The process. No, your conduct, Mr. You are a defaulter. There is no equity in your favor, right? You are a defaulter, not making payment of the amount of loan and filing successive writ petitions. So you advise the petitioner instead of paying fee to me, you give it to bank. So that much of amount will be reduced. It's all why you understand, right? What can be done? Your account has been declared NPA. Now they will take an action under 13(2). You will again file a petition. Then we will tell you to go to 17. You will not go. Why you are running away from DRT? So what will your account has been declared NPA? Now the bank will proceed against you under 13. What can be done? You have, and why have you not approached despite, madam, what happened to that? Unable to get it? Strange. WP number 22070. Unable to get of 2020. Then to give. See. Huh? 13.4 is also initiated. This is the order.
Yeah, it has
No?
page number 115.
Nothing. No 5. Yes. In this rate petition, comma. The petitioner who is a defaulter and want to pay. We have said make a fresh application. They will supply. But we will not permit you to keep this writ petition pending and seek stay.
Much of this. Lordship. At least this matter needs 1 week time.
Huh?
1 week time will be permitted.
Last date also. You are Mr. Shiv Kumar.
Yeah.
You said Mr. Saxena, who was unwell.
He's still unwell, so I'm engaging.
No, but engage some other counsel.
Yeah, I'm engaging.
Or you equip yourself. There's nothing in this case so that he alone can argue. You are seeking a permission to clear the waste material by using eco-friendly recycling stone crushing unit. Correct?
We'll have to file a counter minutes in this matter. What has happened is since 2008.
Let him first argue.
Yes.
Learned. Mr. Next date we will not be adjourned. We will not adjourn it. Repeatedly, this is second occasion.
Definitely not that chance.
We will dismiss it. What you tell us, what is the petition? Tell us what is the
Lordship, petitioner obtained permission from MRO the year 2012 for erection of a temporary mobile plant to remove the
Heard on the question of admission notice on behalf.
Respondent number.
In this matter, my lord, I'm appearing for respondent corporation, my lord. In the last occasion, there was a direction, my lord, to file an additional affidavit regarding the steps and measures taken to protect animals.
Not filing.
Yes, ma'am, we are already filed in 4/10/2023. At USR number 98650.
File a reply for that, your lord. But
Learned counsel for the petition.
counter file. Counter file.
What is it?
Issue is not that certain agricultural lands are included in the forest.
Huh?
Certain agricultural lands relating to the farmers have been included in the forest. But I filed my count stating that all has been de-reserved by the forest department and passbooks has been issued to the concerned rights.
Nothing. There's no particulars. Wait. You are respond number 8? No.
But I am for the respondent number 7, 24567 R7 file counter.
So then you give it to. I'm looking.
There are 7 below. Are 10 onwards, bro. Are 10 onwards, bro. They have been de-reserved. Passbooks have been issued to the concerned rights. But their grievance has been redressed below. Statement can be recorded, bro.
Paragraph
10, my lord. After the district forest officer, by his letter dated 27/4/2021, reported that the following 6 survey numbers have been de-reserved. The total de-reserved is acres 1420 acres 9 guntas. The split up has been given. As against the de-reserved extent of 1420 acres, 16 acres was covered by the government amenities, roads and
Alright.
buildings, canals. The net extent in acres.
Yes, yes. Mark the presence. This public interest litigation. Yes.
I'm for the third respondent, my lord. The writ petition,
You have to tell what is the date. When will you hold?
my lord, your lordship, may adjourn after November 30, my lord, because the election, assembly elections are,
No, that we know. So what thereafter? When will you hold after that?
not in the month of January, my lord, because my lord, the term
I
of
just like you feel like January is a better thing to do. That's why. Don't be so casual, mister. Your statement has consequences, right?
yes. The term,
Mr. Prasad, like he doesn't understand the gravity of the situation. Like, so please tell us the grievance is that the elections of Zilla Parishad, Mandal Parishad, Gram Panchayats. So now
But I'm told.
we know he's telling us what we already know, that assembly elections. So thereafter, when will you hold? That is the statement. He says January. So we can direct from 1st January till 31st January anytime. Like he's saying January. So we will say 26th January you hold election. He's agreeing.
My lord, an affidavit from the responding authority will be placed before my lord. Affidavit, my lord, indicating the date.
What like?
But my friend, my lord, what I was submitting is
the terms of the surpenses are also coming to an end at December. But let the affidavit be filed before my lord. Lordship.
Who will file the affidavit?
The third respondent, Commissioner Panchayat Raj will file in a week's time. In a week's time.
Let them file. Mr. So and so. Now, till November, you will agree. You will agree that 30th November, nothing can be done. Learned counsel for so and so.
DPO. My lord, in this matter, I'm appearing for respondent number 3, GHMC. My lord, a report has been filed before your lordships, my lord, regarding the awareness programs conducted by GHMC regarding usage of existing toilets. My lord, we have repaired and restored the old toilets, my lord, and we filed a rejoinder to the newspaper article at page number 4. My lord. Thereafter, we conducted page number 11. Your lordship may take page
Like
number.
how many places where this all it should be in a tabular form?
Yes,
Where?
we have the newspaper article at page number 11, my lord. They accepted.
So you are relying on newspaper item, right?
Like this PA.
You are an authority, you are relying on news item.
This is a newspaper taken up.
So which locality, how many toilets you have provided?
In No.1,
Mr. Whether there is one voluntary organization, right? Have you heard the name Sulabh International? NGOs working in the field. That's known. He's saying no.
Page number.
Say award winner also.
He says he doesn't know. We are surprised that he doesn't know.
Unfortunately, my lords, the founder passed away, I think, last month.
What? How many places? What?
The subject of property is at Naubat Pahad, my lord. It's a place where public toilet. The film was taken up on a newspaper.
We want a chart where which locality, how many toilets you have provided. Not like this.
Report has been filed, my lord.
And you are relying on a news item.
No, this, in fact, this writ petition was, this is a taken up PL on a newspaper article. My lord, of
It may have been taken up, but we can monitor, right? So whatever newspaper will say, we will decide, right? Then they very good, right? You get the published in the newspaper. We will say newspaper says so. Therefore, petition is dismissed. Newspaper says so. Therefore, it is allowed. Very easy. Well, very easy job. News item dated so and so is part of the order. A petition is allowed. It's very easy for us.
What details have been provided in the report dated 24/8/2023, my lord. Entire details are provided, along with the photographs and the action, even a letter word addressed to the National Commission for Women, my lord, Government of India, after the steps which have been taken by
No, have you given this thing? Which locality, how many toilets?
Yes,
have
my
you
lord. Yes, my lord.
Where?
Yes, page number 2, my lord.
Page number 2 of?
Page number 2 of the report dated 24/8/2023.
There's no report.
We have filed the report.
This one. Yes, sir. Page 2.
Para 2 minutes. Page 2, my lord. Para 2 it starts, my lord. Page number, para 4, my lord.
No.
Existing.
This is all vague. Yes. You give us how many toilets area wise.
Yes.
Chart. Learn. Who are you?
Third respondent, GHMC.
GHM Council for GHMC is directed to provide a chart disclosing
My lord, I am appearing for the appellants. My lord, first, I express my inability to be present when the matter was called.
Huh.
I'm grateful for the courtesy, my lord.
No, this thing, Mr. Prasad has to argue. Yesterday he was arguing.
This is a passed over matter.
Oh, passed over, yeah.
Appeal.
Acha, we thought that further here. Yes.
My lord, I'm grateful for the courtesy, my lords, of extending.
No, yes, please.
My lord, I'm appearing for the appellant. My lord, this appeal arises from, my lord, an order passed in a batch of writ petition, where the title, my lord, of the writ petitions has been decided. Then your lordship had occasion to, my lord, deal with one of the batch cases. My lord, in WA, my lord,
Yes.
697
He is claiming the benefit of that use addresses accept notice, issue notice.
Yes,
notice on behalf of respondent is accepted by Mr. Harinder Prasad. Self-read, not possible.
No, my lord. I won't
Yes.
make
Yes.
such an unreasonable request.
Next.
But I was bringing to my lord's notice, my lord, through my counter which I filed in 525, Table 525, my lord, I've read the para 9 I had read, my lord, I would like to read further. To bring to my lord's notice, my lord, the aspect of the factors which were considered by the housing board, my lord, during the meeting held. But, my lord, I'll just
para 1 minute.
specific stand was taken in the counter, my lords, at page 72. Page 72 minutes. Line, para 3, line.
Which petition, Mr.?
This is
525.
Table 525. But kindly, but I'll be permitted to read from line 4, line 3 of the para 3.
How, as regards allegation.
It is submitted the contrary to what is meant. Andhra Pradesh Housing Board has been constituted in AP Housing Board.
No. How does it read? It begins as regards allegation.
Allegation made in para 2.
Go read.
The affidavit is submitted the contrary to what is mentioned. The Andhra Pradesh Housing Board has been constituted under AP Housing Board Act 1956 to provide for measures to be taken to deal with the housing accommodation and not for meeting the needs of the houses for needy people and needs of the houses for the needy people. Under the Act, the board is competent to acquire and dispose of properties, but while disposing of lands, it can be done by way of conducting auction. Under Rule 29 of the AP Housing Board rules, the board may lease or sell any land or building vesting in it by way of public auction only. It is therefore humbly submitted that the AP Housing Board does not have the ability to allot land in manner not prescribed under the Act and rules, and the employees do not have any right for preferential treatment in the allotment of land except for the prescribed proportion indicated. The regulations framed for the purpose is provide reservation of 10% of houses for government employees, board employees at the time of draw of plots. But thereafter, again next page, as regard para 6, specific contention was raised, 160 rupees was fixed and was paid.
para 6, as regards the allegation made in para 5, it is submitted that the same or not petitioner did not pay the cost of the plots at 116 per square yard. Therefore, the allegation made the petitioner respect of payment is not correct. The request for the registration of the plot in their favor therefore cannot be entered in any event. Thereafter, it is true that the first respondent issued GMS 32 dated 12/9/2006 in supersession of earlier GO 2 dated 10/10/191 and further permitting the respondent to consent and allot individual flats to employees in lieu of the allotted plots. The further argument regarding refund of the amount together interest is also not in dispute. I am further advised to say no show cause notice as such when necessary. The very official allotment is not traceable either to the statutory right or vested right upon the petitioners. But thereafter, my lord, I have read the para 9 to my lords, my lord, earlier. It is para 9, line 3. It is further submitted in view of the change requirements of the housing needs and view of the fact that there is severe constrained availability of land in twin cities. It was felt that the housing needs of more number of people can be met by making provisions by construction of flats rather than plots. Further submitted, there is no proposal to sell plots to third parties. The housing board will utilize the land for the purpose of construction of flats. But what I was trying to contend is not 13 acres, initial 13 acres extent was approved by the state. Second time around in 1994, it left to the board to take a decision because the land was in their possession. That decision of adding 13 more acres, making it to 26 acres, was not approved by the state. There is no record to show that 26-acre extent was subsequently approved by the state. It is only the housing board decision which was forwarded to the state, and that went on with a series of resolutions passed and the cabinet approval in the first instance. Second time, when in 2005, the Council of Ministers had approved one more request from the Vice Chairman saying that in lieu of land, flats can be allotted. That was also by way of a resolution in 2005. Now the contention also is raised before my lord saying that though we wanted to pay, 217 people wanted to pay, they were not allowed to pay. Not kindly see, my lord, 1991 is the allotment. 2001 for the first time they contend before the 2001 of the proceeding by the authority, directing them not to collect. Since the decision was pending with the board and the government with regards to the factor of allotment of plots or flats, and also considering the aspect that there are several people who have retired, some have died, and also the rates which were suggested by the board were also not accepted by the government. All these issues were pending before the state. Finally, in 2005, a GO was issued, 32, saying that, indicating that no land is allotted, land costs should not be collected, only flats should be given to the petitioners. But these aspects were not really led to the issuing of 32 GO. Here, by making a statement to the counter saying that no amounts were paid, and the default committed now, they are trying to now say we also stand along with 103. 10 years having not chosen to pay, having committed default, that made the learned single judge to create a dichotomy between the petitioners who have paid and petitioners who have not paid. And 217 petitioners.
When was the allotment made? 91?
91.
Date?
4691, you have to find that at pages 80 to 85, in writ appeal 470.
And then this thing, what was the time under?
Announcement was made in 2001.
2001. Amounts were not paid, is a fact. Original. Even the learned judge has found there's a default in payment. That is how it resulted in saying that 103 people can have to be awarded and 217 people they are not entitled to, left to the government to take a decision. At that stage, my lord, what I am submitting for my lord's place, there is a decision by the cabinet, my lord, approval is there for extending the benefit to the petitioners, my lord, in the form of apartments. 203 square yards, if the land is there, my lord, I am told, my lord, 1 square yard will 9 square feet area can be constructed on a square yard of land. But today, my lord, I am again submitting for my lord's consideration. I leave it to the court, my lord. I am told the value of the land is more than 2,000 crores today. 2,000 crores, more than 2,000 crores is the value of the land.
May not be relevant. For
pretty much state largest, not putting it to the use. What I am trying to submit is 26 acres can be better.
No. So this thing, Mr. There was an order of allotment, right? 4691.
Yes.
Where is that? Let's see, what are the terms and conditions of allotment? And when did you, 2001, when was the amount due was to be paid? Like it was deducted from their salary, right?
That is GOMS number 2 housing.
Which?
GOMS
525.
525, no, I'll just point out what. Page number 83 now, page 80.
525, no?
Yes, page 83.
83.
May I read it, Raj? The Vice Chairman, Housing Commissioner, Andhra Pradesh Housing Board, in this letter for cited above, has allotted the NGOs Union of Andhra Pradesh Housing Board represented to categories to whom the plots were not allotted, and requested for allotment of developed plot in the same analog as was allotted to the board employees earlier. The Vice Chairman, Housing Commissioner, Andhra Pradesh Housing Board has further said the board in its meeting held on 29/7/88 employed to recommend, not employed, to recommend to government for recording permission to allot 115 high income group, 181 low income group, and 24 HWS plots to 320 board employees to the extent of 13 acres of land at Kupatpalli at the rate including the cost of the land and development charges, subject to condition that no employee shall sell away, it's not call away, but sell away the land. If there is any violation, the land with the structure, if any, will be resumed by the government. The government has considered the above request of the Andhra Pradesh Housing Board and hereby accord permission for allotment of 115 MIG, 181 LIG, 24 EWS plots, 320 employees of Andhra Pradesh Housing Board, extent of 13 acres. On the southern side of 4th to phase to
No, this is the government order, Mr. 10th of January. Then at the rate of 45 rupees.
Yes.
So when, how, in what manner this amount was required to be paid? If you are taking this plea that they are defaulters, you will have to say that what manner this 45 rupees was required to be paid till what time?
If I'm sorry, Malad, to interrupt. The Lordship's permission, Malad, may I say, Malad, September 1991, in pursuance of the GO, Vice Chancellor, Malad, Vice Chairman issued a proceeding saying that it should be collected in 30 installments. And so far as 45 rupees, so for that is, Malad, in my case, Malad, I do not have the other papers. Writ appeal 120, page 73, Malad.
Writ appeal 120.
120, Malad, page 73.
Madam.
Page 73, Malad, I'm sorry for the...
1 minute. We will get it. 1 minute.
Yes.
Page 73.
Malad, I'll read, Malad, I've got the paper. Page 73, I'll read. I'm grateful for me.
May I point out? Malad?
May I read, Malad? Page 73?
Yes.
No, same thing, 10th January 91.
Yes. While enclosing...
No, at the rate of 45 rupees per square yard subject to so and so condition, that's it.
Yes.
So what? We are asking what manner this amount was required to. He's saying some 13 installments.
30 installments.
30 installments.
Where is that order?
In the same proceeding.
In the writ appeal.
Your Lordship would
Housing Board requested to recover the cost of plots, line 4 months. And
page 73, Your Lordship may see of writ appeal.
I'm reading.
120.
It's development charges.
Prakash is drawing Your Lordship's attention to from the virtual court.
In 30 monthly equal installments.
30.
From the salaries of the employee working under the respective divisions to whom the plots allotted with effect from October 91, payable on 1st November 1990.
And all of them were paid up by...
has been done with regard to all 320.
All paid up by 1994. Your Lordship, last evening I pointed out to Your Lordship, Housing Board's communication saying that it is all paid up. Your Lordship will get that at page 30 of the additional papers filed yesterday, where it is admitted that it was all paid up.
If I'm permitted to clarify, Malad, The factually, Malad, the what is being submitted by the learned government leader, Malad, my senior friend Malad, is that 116 is not being paid. 45 rupees everybody has paid, Malad, by 1994. That is admitted case.
16
What has not been paid is enhanced amount, Malad, from 45 to 116. That 116, Malad, which has not been paid because it was asked in December without fixing any time of 2000. But if your lordships look at the list of dates, Malad, my friend Malad might have missed this. On 16/12/2000, Malad, in the second page of my list of dates, your lordships will get allottees.
Where is the synopsis? Even yesterday it was given.
List of dates, Malad, 120.
Ah.
Your lordships may see, Malad, my friend might have missed this. But enhanced amount was asked to be paid by proceedings dated 16/12/2000. But my colleague is there, she can also give the copies. But this middle of page 2, 16/12/2000, your lordships may see, Malad.
Yes.
Your lordships have got it, Malad. Letter by second respondent wherein the allottees were asked to pay the difference amount of 71. We have said, Malad, the said letter has no cutoff date for the payment. Malad, in 15th February 2001, but instructions have been issued, don't collect. So within this time, Malad, a 1.5 month or 2 months gap, 103 have paid and others, Malad, could not pay because they were refusing to pay. So my friend is not correct in saying that we have defaulted in payment. So far as 45 is concerned, everybody has paid, Malad.
If I paid, I was pointing out of 116 rupees, what?
And
The counter which is
interestingly, my lords, the learned single judge does not say we are defaulters. The learned single judge says we have not paid.
not paid. Not paid.
Not taking into fact.
And let it complete.
Malad, may Malad complete page 149, your lordship.
Yes.
In that writ appeal, page 1.
We have got it.
They have instructed saying that Malad, they should not be collected. So where is the
All right.
Your lordships
Yes.
on 15/2/2, so with regard to the registration of the plots in the name of the board employees, Principal Secretary to Government Housing Department has talked to me over telephone. Matter is under examination of the government. I therefore request you to see no further action is taken until the further orders in this regard. That's how they stopped collecting. Incidentally, 103 people have paid in that. So absolutely, there is no distinction whatsoever which can be made between 103 and 217. All 320 have paid so far as 45 rupees is concerned, which was fixed originally in 1991.
It is basic.
Yes,
Yes.
Sorry for repeating, Lord. Apart from this the geo which is set aside where I am an appeal before my lords, Lord. What I was trying to contend is, Lord, kindly see, Lord, the object, Lord, of is providing a residential accommodation in the city for the employees was the. But what the board has now done in the impugned geo before the single judge was, may I read the geo, Lord, for my benefit, Lord?
Yes.
At page 82. Government after 82 minutes of this 525. 525. I'm so sorry, minutes. May I read? Government after careful examination proposal received the reference second and third cited read above from the Vice Chairman and Housing Commissioner AP Housing Board hereby cancel the orders already issued in the reference first read above. Government hereby permit the Vice Chairman Housing Commissioner AP Housing Board to construct and lot individual flats to the 320 employees of AP Housing Board who were earlier allotted 115 MIG to 24 EWS individual plots transferred in southern side of fourth phase subject to following conditions. Permission is accorded to the Vice Chairman Housing Commissioner AP Housing Board. Construction of individual flats for the employees appropriate to the category time of service is allotted at current rates of construction without charging them on land cost.
10:30. Shall we tell him? You call that council. The other one, first behind you, young man. Mister, we are watching that since 10:30 you are yawning in the court. If you have not slept, go home. It's not a sitting here and yawning like since 10:30 you are yawning. What's the problem? Huh?
Just thinking of that. I had a fever.
So then go home. There's no, why sit here and yawn in front of court hall at 10:30? We saw that at 10:30 just now. 3 times we have seen you sit in front row and yawn. Please, if you are not well, please go home. Yes.
Permission is paravan. Permission is accorded to Vice Chairman, Housing Commissioner, AP Housing Board, construction of individual flats for employees appropriate to the category and type of service which will be allotted at current rates of construction without charging them on land cost. But this is one aspect which I brought to my lord's notice. Interest and 20% per annum will be paid by the IP Housing Board, amount paid by the employees initially towards the land cost, if any, which will be offset against the cost of construction. The current current rates to be charged to them. Approval of the AP Housing Board shall be obtained by the Vice Chairman, Housing Commissioner, AP Housing Board of the scheme.
So, sum and substance is, Mr., that the overriding public interest is that you feel that this, due to acute paucity of accommodation available, right, land, it can be provided for more people. Therefore, you propose to construct a flat and allot them.
But while all this was there, my lord, in place, but there is a GO issued by the state, my lord, GOMS 244, which was directed to be incorporated in this by subsequent housing authority. The GO reads as follows: 243, 244. But I'll just on this book for to make copies. But this specifically deals with land bank allotment of land for housing to government employees. There are guidelines. But this is a case study. This is a GO issued in 2005. February 2005, which takes care of the method of allotment and how the same has to be considered, and it also takes care of the cadre of the employees. Cadre, IAS, IPS, non-cadre head, superintendent.
Where is it?
May I just pass on the notes? I couldn't make copies immediately. May I pass on the book?
We must be having the book now. Which book?
But this is the book which is printed by the author land report. And book on land matters. Thanks.
But where does it say so? It's not telling of the material name. Where is that difference? How? Asking how it looks.
So according to you, Council, this 244 was the basis for issuing 32, GO 32.
In condition, in 244 were directed to be incorporated by issuing 32.
Is there any reference in GO 32 to this GO?
In the counter, we are searching. But may I just pass on this book? I'm sorry for the extra copy not to. May I read this?
Yes.
May I read this? Lordships, reference is made to the earlier GO issued not next month. Order GO 6 threat above. The orders were issued for creation of land bank to meet the housing and other institutional requirements of various systems of society. Orders were issued in the seventh cited with policy guidelines pertaining to allotment of lands to various categories, and it was ordered separate orders shall be issued pertaining to conditions of allotment of government land to government employees. Accordingly, following orders are issued. Land shall not be allotted in favor of individual employees. Employees shall have to form into a group or a cooperative society for availing the facility of allotment of land for a flat, public or site. Society or a group shall have minimum of 12 members. Applications for flat outside shall have to be made to the concerned collector and disciplinary state. The collectors in turn shall obtain necessary approval for withdrawal and allotment of land from out of the land bank to the empowered committee and government. After approval of the empowered committee, the government further action will be taken by the collector to make scheme operational. So the collector shall be nodal authority to make the scheme operational, shall be competent to allot lands for housing purposes by housing society or group of employees the rates of stipulated. Following the above outlined procedure, collector shall monitor the implementation of the scheme very closely and send monthly progress report to government. On alienation of government land, the society or group of concerned in turn shall allot individual house sites, flats, as the case may be, the individual members, title of the plot or flat shall be conveyed to the members concerned the society through a registered sale deed. Condition: employees should be a member of society or group. Employees who are forming into society group are advised to complete the admission members before making an application. So facilitate the society to arrive at extra requirement of land, which can be calculated as per eligibility criteria. Make an application. Some other employees are not part of society, they can be formed into a separate society group request for allotment. This approach would limit the post allotment litigation to minimum. Society's group shall not allot house sites, flats in respect of any other member whose name is not figuring in the application submitted to the competent authority. The employee should be an approved probationer by government, public, local body. He should have completed minimum of 5 years of service. Employee shall be eligible for one government house site or flat during his service or service. Both husband and wife are in government only one. The allotment of house sites shall be completed with within a period of 6 months from the date of alienation of the land. But 11, if your lordship sees 10 to 11, an employee who is allotted a house site flat should not sell such site flat for a minimum period of 15 years. If the society allots open plots, open spaces available in layout or changes layout without approval from competent authority for that approved layout, the present secretary or officer of the society liable of periodic action, changes made if any shall become null and void. This fact of allotment of house site flat shall be recorded in the service book of employee concerned. The employee would be entitled for concessional allotment of land only for one time in his service. Each member of the society for whom land flat is allotted shall have file an affidavit stating that she was a member of any society which concessional land allotment was made. He shall also give an undertaking that she shall not avail such facility in future. Size of the plot depending on their status, cadre. The IAS, IPS officer, they are entitled for 500 square yards. Non-cadre head of the department, 400. Second and third level gazetted officer, 300. Superintendents, assistant section officer, senior 250. Telephone operators, 175. Attenders, 100. Sufficient land is not available for allotment. Land can be divided into plots and ratio number so categories to 2. The cooperative society group are liberty to decide whether they would shoot, but
Yes.
These are the conditions where they were expressed by the state also to be incorporated, and subsequent to which the present GO was issued.
Page
So you can refer to page 67 of the same paper book. Page 67, same paper. Page 67, para 8. Para 7. Council of Ministers are Council of Ministers.
120.
Para 7, page 67.
12/9.
Council of Ministers approved the resolution. dated 1/4/2005, registration of 320 allotted to API with the conditions 244 revenue. Case of allotment of land will be made applicable in this case.
Where are you reading? Which page you read?
Page 67 will say 525.
525.
Page 67. It has been indicated, not. Para 7. The Council of Ministers has approved by resolution numbers 110/2005 dated 1/4/2005 for registration of 320 plots allotted to the employees of AP Housing Board. The conditions stipulated in GMS 244 Revenue Department dated 28/2005 in case of allotment of land to APHB employees made application. Thereafter, my lord, para 9, while the matter stood, thus the VC and AP Housing Board has submitted the revised proposal during 2005, December 2005, request to cancel all the allotments and to provide.
Usually they were collected in the plots. Because it is changing in 52, they have noted. And this will be sometimes we will leave it with we can't resist. We this policy. We are going to be time. It's a very clean case. Yes.
Then, while the matter stood thus, the Vice Chairman, AP Housing Board, has submitted revised proposal during December 2005 with a request to cancel all the provide HIG, MIG, LIG and propose other scheme following reasons. Only 103 people have paid the full amount asked for, and 270 people have not paid the full amount. The GO referred to in cabinet decision relates the payment of market value as per basic value. What has been collected from these employees are in the nature of only a fraction of market value, such as ₹5 against market value of 180. Several people have bought by way of either concessional allotment or outright purchase flats. Several people have retired in the meantime and dead. Some have been removed from service. To give semblance of fairness, we have sent proposal for administering the scheme, but it appears that it's quite difficult to administer. The submitted Vice Chairman Housing, AP Housing Board, recommended to cancel allotment to provide HIG, MIG orders in the proposed other scheme at a concession rate without charging for land value. Charges should be based on the cost of construction only to 103 people, and also to adjust their contribution incorporating an interest of 20% the time the money has been given. Similar offer can be given to others too for the same price. The revised proposal of so-and-so will be presented by the Council of Ministers. The Council of Ministers approved the recommended resolution dated so-and-so. Modification to the earlier resolution dated 1/4/2005. Revised proposal submitted second dispute is now being
because there is no to be
Decide until maybe on the ground, so they not saying that they are already happening. So why do we go to the just keeping along with you? Because we can't explain these people. Clear assigned the date of the survey. This is literally right. To say it's really coming. This way. If we log in, the case of the division and the overall surveillance data right for we will go in the judgment. Let them money subsequent to the change function. Putting that into life. So we need to do if it is incorrect. We from which is which a party will interacting on the other side itself. It is very it is with mountain which divisions. It is some seed purposes condition important investment. Here we have completely husband. It is condition with the can we see the past election is it and the consequential direction of finally the way to bring the unity. In case we is dying of the any part, everybody gets to be even these meetings is using the time that is not the case in the respondent that you will to your video. Yes, Russian was being removed. Even like it means clarifying that it means it means don't means yes.
But Housing Board Act, Section 29 also permits the board member to change its program. The program deals with specific housing scheme for that period, for a particular year. But 29 kindly I just read 29 for my consideration. The board may at any time vary program or any part thereof included in the program sanctioned by the government, provided that no such variation shall be made if it involves an expenditure in excess of 10% of amount as originally sanctioned for the execution of any housing scheme included in such program or affects its scope or purpose. The
We'll
power
continue after the break.
सब लेते हैं
Yes.
Page number 15, Your Lordship.
One
Page
five.
number 15, yes, 15.
15. Certified copy today.
Page number 19, my lord, 19.
Page number 26.
Page 19, my lordship.
19.
19.
Page number 25.
16, my lordship. 16.
Certified copy today. They know who's taking dictation. You know. It is to be typed today. Today. Yes.
Before I start, Lord, I stand corrected in one aspect, Lord. 45 rupees was paid by the petitioners in all respects, Lord.
All.
Difference of amount, Lord, which was trying to bring to my notice, they were.
No, but is it, can you say in the facts of the case that they were at fault for not paying the remainder amount? It was by a 42 circumstance, somebody paid the whole thing, they couldn't pay.
Why the difference?
Right, but because, see, immediately thereafter, there was a prohibition.
Yes, the difference was because of the extent was also altered. The extent of land was also altered.
Altered.
From 13 to 26 acres.
But you can, in that sense of the word, they can't be treated as defaulters, right?
I stand corrected to that extent, Lord.
All right.
But one more aspect, Lord, I just wanted to bring to my Lord's notice, Lord. The Lordship sees the prayer in the writ petition, Lord. But virtually, my Lord, a specific relief was sought for, seeking a direction, my Lord, to the respondents. Your Lordship sees the order also. Page 11. But page 10 is the prayer, page 10. Petition, the left hand side. Petition under 26 of the Constitution of India.
Which WF 525?
525. Page 10. That's the prayer. Extract of the prayer. WP
Page
number
10.
2265 2006. The court will be pleased to issue a appropriate writ order or direction, more particularly when the nature of writ of mandamus, declaring the GO 32 housing Department 12/9/2006, in cancelling the allotment of outside plots, the petitioner is arbitrary, illegal, unjust, indiscriminate violation of principle of nationalism. Apart from being without jurisdiction, consequently set aside the same with a further direction to respondent to register the plots in. I will now straight away go to the judgment of the Honorable Supreme Court with regard to legitimate expectation, which was, it is 2019 9 SCC 710.
2019
I'll pass on copies.
9 SCC
9 SCC 710. Kerala State Beverages Corporation Limited, where a promise was made to rehabilitate the daily wage workers. Kindly go to para 19.
Para 19.
19.
Yes.
Substantive legitimate expectation. Expectation entertained by a person may not be found to be legitimate due to the existence of some countervailing consideration of policy or law. Administrative policies may change with changing circumstances, including changes in the political complexion of the government's liberty to make such changes, something that is inherent constitutional form of government. The decision maker's freedom to change the policy in public interest cannot be fettered by applying the principle of substantive legitimate expectations, so long as the government does not act in an arbitrary or in an unreasonable manner. The change in policy does not call for interference with judicial review on the ground of legitimate expectation for individual or a group of individuals being defeated. The assurance given to the respondent that they would be considered for appointment, this is in regard to that specific case. Appointment in future vacancy of daily wage workers according to the respondent gives rise to a claim of legitimate expectation. The respondents contend that there is no valid reason for the government to resile from the promise made to them. We are in agreement with the explanation given by the state government. The change in policy was due was to difficulty in implementation of government order dated so and so. Due deference has been given to the discretion exercised by the state government. The decision of the government to change the policy was to balance the interests of the displaced quarry workers. Large number in that context of the case was referred to. I was just trying to bring it to my lord's notice.
In 23, there is a constitution bench decision on with regard to legitimate expectation.
Right.
Constitution bench decision with regard to this legitimate expectation 23. Have you come across that? I mean, 2023. In that NCC case, we had used NCC. All right. Yes.
This is the only judgment which I am relying upon. But I am also submitting to my lord's the prayer in the petition which was sought for directing the respondent to register the same.
So you have taken a ground that some of them have been removed. Who has been removed?
Those details are not fulfilled, but I have taken a stand. Some have retired, some have been removed, some have passed away. But if your lordship sees page 26 of the judgment, the learned single judge. Page 26. When the matter stood thus, may I read, Manoj?
One minute.
Internal page 16.
1 minute. This is Shiv Nandan CT versus High Court of Kerala. 2020-23 SCC online. Nine.
Sivanandan C. Well, this was brought to your lordship's notice. Paragraph 49 of that judgment.
Yes.
Page 26 of the judgment.
Page
26 of the paper, 525.
Internal page.
Regard to the details of one of the persons.
Para what?
26. What's top page 26.
Internal page 16, my lords, for convenience of your lordship.
I think page 26.
Internal page 16 of the judgment.
16.
1/6 of the judgment.
No, but there is no paragraph I mean, if you could refer, it will be paragraph, which para of the judgment?
This is point number 1 to the page 24 it starts. Points for consideration, point of para 13.
Above para 14, it's a continuous para. It starts as paragraph 13.
Para 13
Ah.
starts.
Undisputed points 1 to 3.
Paragraph.
Then page 26, running page.
Come to
Page.
25.
Running page.
That will be internal para 16.
Para page 16.
Page 16.
Starts with
Page
why the
26.
matter stood
The
thus.
matter stood thus.
Yes.
The Vice Chairman Housing Commission AP Housing Board submitted the revised proposals during December 2005 with the request to cancel all the allotments, provide houses at concessional rate without charging for the land value proposed either than these details were 103 people have paid the full amount asked for, 217 people have not paid the full amount asked for, whereas the GO referred to the cabinet relates to the payment of market value as for basic value. What has been collected from these employees is nature of only a fraction of market value, such as ₹5 against market value 180. Several people have bought by way of either concession allotment or outright purchase flats. Several people have retired in the meantime and dead, and some have been removed from the service. To give semblance of fairness, we have not sent proposal for administering the scheme. It appears that it's quite difficult. This is what I was referring to. Bring it to my lord's notice. Not there is a different number of people retired. And deeply obliged.
Malad, sir.
Please, your lord.
May subject to the pleasure, Malad, if your lordship
Yes.
first reply, and then Malad, my friend, will continue. Mr. Ravichandra. Malad,
Yes.
one of the contentions raised by my friend Malad, now he has corrected himself, saying that 45 rupees everybody has paid out 320. Then, Malad, so far as enhanced is concerned, my friend was under the wrong impression, saying that while allotment was in 1991, we have not paid till 2001, which is incorrect. Enhancement was only in December 2000, Malad. And within 2 months, Malad, 16th December 2000, Malad, they've given a proceeding saying that we should pay the difference of 71 rupees. Within 2 months, Malad, they've said that stop every further action and don't collect anything. So as earlier also, Malad, it was collected from the salaries, Malad, by the disbursement officers. They have instructions, Malad, saying that we should not deduct and we should not collect. So that's how, Malad, it cannot be said that we fail to pay. We stand on the same footing as that of the 103. Malad, I am again, Malad, repeating at the cost of repetition, as I said in the original argument also, we are basing upon the judgment, Malad, which has come to the learned single judge has come to the conclusion, Malad, that it is an arbitrary, impugned order is an arbitrary proceeding. That's how liable to be struck down. Having said that, Malad, confined the relief to only 103 on the wrong premise, and Malad, an artificial dichotomy saying that 217 people have not paid, which is incorrect because we were not allowed to pay. And then, Malad, another aspect has also not been considered by the learned single judge. It has not stopped at 116. Then it was increased to 204, referred to the cabinet subcommittee, which I have already detailedly submitted. Malad, cabinet subcommittee, Malad, accepted the proposal to give it on the 204, subject to the condition that if something more is required for the development, Malad, employees have to bear. And this has been approved by the cabinet also. And then another contention of my friend is, Malad, on the basis of the GO 244, which is of 2005. Malad, with great respect, Malad, that will not have an application because the first GO 2, Malad, by which we were given, Malad, was in 1991. 1991, Malad, this GO, which is of 244, is of 2005, Malad, which will not have an application. Malad, another aspect which has been pointed out to your lordship is originally only 13 acres was proposed and it has been increased to, Malad, 26 acres. With great respect, Malad, it is not an increase in the size of the plots being allotted. Malad, that increase is on account of the fact, Malad, plots are the same size, because roads and other things, Malad, which are required, Malad, for the purpose of making. And then, Malad, my friend said, first time they have taken the permission, second time they have not approached the government, which seems to be, Malad, factually incorrect. So what I understood, Malad, from my friend's contention is right. Saying that they have not taken the permission from the government is not correct, because the second time, Malad, when they passed the resolution increasing the area, because roads and other facilities have to be provided to have the access to the plots which are going to be allotted to the individual members. But they said it will be 26 acres. When they put the proposal to the government, but government said the land is with you, you can take the decision. That your lordships will get, my lord, in my list of dates, my lord. Specifically, my lord, this has been referred to. Your lordships will get, my lord, in the list of dates. My lord, first, second page, my lord, top. Second page, top of the list of dates.
List of dates.
List of dates, my lord, in 120. Yeah, sorry, my lord, we should have made the compilation, either the government or we should have made a conveyance compilation, my lord, instead of requesting your lordships to go to one page to the other page. My lord, your lordships will see first date, my lord, 29/6/1992. Your lordships got it, my lord?
Yes.
Page top. Board passed a resolution to approach the government for necessary amendment to the GO2 dated 10/1/1991, that is substituting 26 point so and so acres in place of 13 acres for the proposed layout. Extent which has been allotted to us remains the same, but this other extent is for the purpose of providing the roads and other amenities. Cost and development charges recovered from the allottees by 1994. This is the fact, Malad. Then, government delegated the authority to the housing board, stating that necessary action to be decided by the board level, as the proposed land will be under the control of the board. So they have given the consent, Malad, for increase of the land also with great respect. My friend appearing for the government, Malad, saying that no consent has been asked by the government for increasing the land is incorrect, Malad, because this is at page 74 of 120, Malad, because Malad, I addressed, Malad, in 120 writ appeal. If your lordship look at this, Malad.
Dated 28/6/94, your lordship.
28/6/1994 at page 74, Malad, of 120 writ appeal. But in pursuance of the letter addressed by the Housing Board on 4/8/1992, this is what has been stated by this government joint secretary, Malad. With reference to your letter, my lordship got it, Malad? Sorry for the inconvenience, Malad, because compilation should have been made.
I'll read it out, my lord. It says, with reference to your letter cited, I am to state that the matter need not come to the government.
Government.
You may take necessary action to decide at your level, as the proposed land will be under the control of the board, as discussed by the Minister for Housing with you on 27/5/1994.
So, Malad,
this is the letter.
Malad, because of this proceeding.
Yet to conclude. We will hear you.
Because
no, I was only pointing out, Malad, because of this proceeding, Malad, it cannot be said that the government has not consented for increase of the land. With great respect, Malad, at the cost of repetition, land which is supposed to be allotted to the individual members has not been increased. This is the requirement, Malad, for making a proper layout, Malad, to have the access to all the plots, Malad, of the different sizes which have been agreed. Malad, 3 categories, Malad. That's how, Malad, it is not correct to say, Malad, extent has been increased without the consent of the government. Then another point, Malad, which has been argued, Malad, if I might point out to your lordships, Malad, I'm really sorry, Malad. The 2018, Malad, a detailed letter has been addressed by the Malad, vice chairman of the house, vice chairman and Malad, housing commissioner, as late as in 2018, Malad, pending the writ appeals, detailing all aspects which were brought to your lordship's notice, which is filed in writ appeal 43, Malad, by way of a memo. Writ appeal 43, where incidentally I am also appearing in 43 by way of a memo, Malad, USR number 63101 of 21. USR number 63101 of 21. Malad, filed on 26 October 2021. Malad, why I am pointing out this is, Malad, for 2 reasons. Malad, the learned government pleader appearing, Malad, before your lordship's estate is appearing for the state government and as well as the housing board. Malad, this proceeding which has been given by the vice chairman, Malad, completely supporting the case of the writ appellants, Malad, those who could not get the relief, and saying that they are not at fault because we have not collected the money because it was stopped by the government. And then, Malad, they recommended to withdraw the writ appeals. But if housing board is recommending like that, my friend stating that is appearing for the government and as well as for the housing board, cannot argue contrary to this letter. May request your lordships to the court officer has picked up.
Yes.
Page 1, that is original copy. Page 7 neat copy has been typed. I do not propose to read because completely because it will take lot of time your lordship's time I need not take. Just I will go to page 10 para 11. Only relevant paragraphs I will read to your lordship's What my friend is arguing is contrary to this letter of the housing board and stand of the housing board. But this is addressed to the special chief secretary of the government on 6/6/2018. Now your lordships may go to page 10. The APHB Employees Association has filed a writ petition so and so before to issue writ of mandamus for registration of the plots and so and so. A cabinet subcommittee was constituted and then GOMS number so and so, which is in the meeting so and so, recommended to register the plots at 204. This I was pointing out your lordships from 116. It has been increased to 204. Then para 13. Your lordships may see the stand of the vice chairman. A report was submitted to the government-wide letter dated 9/5/2005, stating that the conditions laid down in GOMS number 244 Revenue Department dated 28th February 2004 are not applicable to the housing board employees. Since the instant case, the land was already plotted and allotment also made long back. Layout was approved, drawal of the lots held, but fixation of the rate and registration of the plots in favor of the individuals only left out. But the reliance on 244 is incorrect is my submission. Then going to para 18. Para 18 at page 13 entire thing is in our favor, but I am reading only relevant paragraphs to save your lordship's time. Yes, Since then, your lordship got it, para 18? Your lordship must see para 17 and 18. Probably because of the ambiguity in the High Court order dated 30/12/2008, 9 writ appeals were filed by the employees in their individual status and also through their association. Housing Board has also filed the writ appeals. Since then, the employees have been time and again requesting the government to take favorable decision at an early date considering the fact Board did not prescribe any time limit for payment of the enhanced amount. Board only has stopped the collection of the enhanced amount because the government instructions. And 3, all the 320 employees have paid amount as prescribed in GO2 on 10/1/1991 and that they are ready to withdraw the writ appeals. The employees have also been requesting for handing over the physical possession of the plots pending development and registration as they paid originally prescribed cost of rupees 45 per square yard by 1994, which is more than enhanced land cost of rupees 16 per square yard because till today the board has not spent any amount. This 45 rupees is consisting of the value of the land and the development cost. It is not the value of the land itself. There are two components. So 204 enhanced amount also, cabinet also says, if the development charges go up, you have to charge with the employees. So the component 45 includes the two components, land value and the development charges, as they paid originally prescribed, which is more than the enhanced land cost of 16 per square yard because till today, board has not spent any amount towards the land development except the layout charges paid to HMDA and that they're willing to pay the balance development cost as per the actuals before the registration of plots. HMDA has also approved the final layout on 28 May 2010. Which clarifies that the board has made efforts for implementation of the allotment of the plots to 320 employees, even the writ appeals pending for final hearing in Honorable High Court. The employees have been representing that more than 50% of the allottees have either retired from service or expired, and remaining allottees also at fag end of their service. The board-wide so-and-so submitted a factual report to the government with a request favorably consider the request of the employees. And concluding paragraph, para 20 at page 14 of this memo, your lordships must see. In view of the circumstances explained above, the government may please to take the suitable decision on the request of the employees for physical possession as provided in the Board Act for allotment of the plots rules conform to so and so and to register the plots, considering that all the allottees have paid an amount of prescribed in GO2 housing dated 10/1/1991, the rupees 45 per square yard, which is more than the enhanced land cost of 16. But 116 contains two components. But 16 is the land cost, 100 is the development charges, which they have not incurred so far because they never developed, even according to their letter. The difference amount between the actual development cost and the cost already paid after the adjustment of 16 per square yard. So the land cost may be collected before the registration. This is what the stand of the housing board, Malad, of late in 2018. But with great respect, Malad, when the council is saying that he is representing both the government and as well as the housing board. But submissions made contrary to this, Malad, the stand which is being taken. This has been given to us, and the right to information we have filed through the memo, Malad. This is not being disputed. And in fact, Malad, some portion of it has also been brought to your lordship's notice by my senior friend, Mr. Ravichandar, Malad, during the time when originally we were arguing our writ appeals. So that is how, Malad, it is a clear case where the learned single judge, Malad, went wrong in making an artificial dichotomy, Malad, between 217 and Malad 103. And Malad, finding with regard to the arbitrariness and arbitrary action of the government in issuing the impugned GO 32 in 2006 after 15-16 years of original GO, Malad, has not been seriously, Malad, challenged in the writ appeals filed by the government and the housing board. That's how, Malad, my submission would be. Malad, we are also entitled for the same relief, and leaving it open. Malad, if somebody has been removed for the service, if they have to, Malad, take action with regard to that, saying that he will not be entitled because he has been removed from on some charges, that will be individual case, Malad. Nothing has been indicated to your lordships, Malad, how many people have been removed like that. So far as the people, those who have died is concerned, under the housing rules, Malad, these allotment rules, any allottee, Malad, includes the successors. Allottee includes the successor. And reason is because 1991 is the GO, first GO, Malad, under which we were given. And they got it delayed. The entire thing will not be standstill. Some people might have certainly died. Their LRs will get the benefit. Some people, those who are retired, naturally, because it's now it is 32 years, after the first GO. So people may retire. That doesn't come in the way, of vested right being taken away, and the government cannot say. And the point which was being again and again pointed out is housing scarcity and all that, which has not been spoken to in GO 32. As your lordships have seen, 244 has also not been referred to, because obviously, because 244 will not have an application. That is, what has been stated in the counter, and housing board chairman has clearly explained as late as in 2018 while pending the matters before this honorable court, saying that 244 has no application. So that is how, my submission to your lordships would be. Writ appeals filed by the employees, challenging the portion of the order of the learned single judge confining the relief to only 103 people. Because of the reason, according to the learned single judge, they paid the entire amount is faulty, and requires to give the relief to all the 320, those who are similarly situated. Once it is held, GO 32 is arbitrary, but that action goes, and consequential prayer saying that if 32 goes, we are entitled for the registration merely because of that, it cannot be said. All this has been answered by the learned single judge. Portions of the judgment, all the questions which have been posed before lordships by my friend appearing on the other side has already been answered. And my friend Mr. Ravichandar has brought to your lordship's notice the relevant portions of the judgments, various paragraphs wherein it has been categorically held it will not amount to seeking any specific performance, as the arbitrary decision has been taken by the government. Writ petition has been filed under 226 and deserves to be allowed is what has been said. Only if wrong according to us, not confining the relief to 103 on the wrong premise, assuming that we have not paid. So that's how my submission would be. All stand on the same footing, all are entitled to, whether they are in service or not today, or whether they are alive or not, LRs will get the benefit. That's how association is also filed. That is the reason, merely because some employees died, it doesn't mean that they are not entitled. LRs are not entitled for the benefit. This submission, in fact, there is another aspect of that letter also, saying that Hydernagar area, which earlier proposed to be constructing the flats and giving, has been sold for commercial. They have not built any flats. But my friend said that they will, Recently, my lord, they don't have a history of building any flats and allotting to the people. Lands are being sold, my lord, at the commercial value. Put to the auction and being sold, my lord, HMD and all that, my lord. This can be judicial notice can be taken, my lord. That's how my submission would be. With great respect to my friend, my lord. All the grounds which have been raised are unavailable to them, and my lord, writ appeals, my lord, filed by us deserves to be allowed, while dismissing the writ appeals filed by the Housing Board and as well as the government. Obliged, my lord, for the patient hearing.
May it please you. I won't take too much of time, my lords. I think Prakash has substantially covered everything. But just to put it in perspective, my lords, one argument of the learned government leader was that it's in public interest. My lords, if it was in public interest, it would have to reflect in the government order saying that it was in public interest. My lords, the impugned geo has been read out to your lordships multiple times to show to your lordships that this public interest theory is a subsequent invention of the government. It is not reflected in the order, and it would suffer the injunction of Mohinder Singh Gill. My lords, just to facilitate the court, my lords, I picked up one more judgment that reiterates Mohinder Singh Gill in more recent times, 2021 6 Supreme Court cases. Paragraph 12. My lords, Mohinder Singh Gill has been repeated so often, but I just got one judgment, my lords, to show that that's the good law yet. Kindly come to paragraph 12 of the said judgment. This is three-judge bench of the Apex Court, 2021 6 SCC, page 707. Kindly come to paragraph 12. The action sought to be sustained, your lordships have that. May I read, my lords? Yeah. The action sought to be sustained should be with reference to the contents of the impugned order. Communication at the same cannot be justified by improving the same through contention raised in the objection statement or affidavit filed in the court. This has been subsequently laid down by this court in Mohinder Singh. Mohinder Singh is quoted. Orders are not like old wine becoming better as they grow older. In fact, in the instant case, such a contention of having exercised power under section 102 CRPC has not been put forward even in the counter affidavit, either in the appeal or before so. So that's a factual difference. In fact, the objection is. So Mohinder Singh Gill reiterated that in a counter or in a response, you cannot improve what has been stated in the original document. Division bench of our High Court, presided over by my Lord the Chief Justice, what else? Para 76 of that judgment. They were dealing with summons issued under the PMLA Act. Kindly come to paragraph 76. That would be almost the last penultimate page. At this stage, we may remind ourselves of the famous observations of Vivian Bose J. in Commissioner of Police versus Govardhan Das Banji. He said that public orders publicly made in exercise of statutory authority cannot be construed in the light of explanations subsequently given by the officer making the order of what he meant or of what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect And our intent.
This is Mohinder Singh Gill has been followed.
Same. It's just a reiteration. I just wanted to show your lordship that our court and the Supreme Court in more recent times have reiterated. Whereas the other aspect I wanted, therefore, my lords, this whole theory of public interest will have to go because it was not there in the government order. The second argument, my lords, both he himself corrected himself on the default aspect. Only to facilitate the court, my lords, I drew your lordship's attention yesterday to a specific reference of the authorities, which is at page 34. Page 10 of IA2, where they admit to the fact that government told them not to take the amounts. Therefore, they can't now turn around to say that there was any kind of failure on the payment of the amount. The third point is, my lord, with regards to this 13 acres and 26 acres, my lords, the stance of the government. Please refer to the board resolution with regard to the registration of plots. The principal secretary has talked to me over the phone that the matter is under examination. I request you to see that no further action is taken until further orders. And this, my lords, the board now says, owns up to this. It's not as if we are just palming off a letter which said, this is what the board said, this is what the board meant. In the subsequent letters which are filed with IA2, which I'll show you lordships presently, Housing Board, who is the appellant for this court, says, please permit me to withdraw the appeal. And for cogent reasons that I'll take your lordships through. On the question of this 13 acres being enhanced and therefore the cost, well, let us take this fallacy away if any one of us have it, that this extra acreage is not government land. This was the land of the Housing Board. The Housing Board allotted us land in mentioned proportions. In the earlier GO, I pointed it out. So, those were the lands allotted to us. They realized that some more land is required because for betterment, for park, open area and all that. They write to the government. The Housing Board writes to the government. And as Mr. Prakash Reddy just pointed out to your lordships, the response of the government was, this is your land, you do what you want. So today to turn around and say that it was without the assent of the government, A. B. Whether an assent of the government was required in the first place because the land vested with the government. And if we are going whole hog to say that it was required, even then we will have to now read to say they came to you, they asked you, and you said do what you want with the land, and that is how it was given. The next point was, my lords, with regards to GOMS 224. Your lordships may kindly see the impugned GO is dated 2006. While GOMS 244 is 28/2/2005. There is no reference to GOMS 244 in the references made by the government while issuing the impugned GO. So it is a clear case of them acting independent of that, and that is justified because, as the commissioner wrote to them saying, they do not fall under 244 because the act of allotting plots to them was completed. Therefore, the nuances of allotting plots under GO 244 would not apply to them. And my lords, this argument on specific relief, my lords, your lordship may just test it from one angle. I could not have filed a civil suit against the government because the GO was standing before me. And it's the arbitrary action of the government that has come up for challenge before your lordship. The consequence could be that I'm getting property which otherwise I may have got from them through a specific relief suit. But it is this that was the bottleneck, and that is why we came before the lordships. The only other aspect, my lords, I will draw your lordship's attention to is the judgment that my friend had cited before your lordships, the Kerala State Beverages matter. In the Kerala State Beverages matter, my lords, what had happened was, The policy on beverage was changed. As a consequence of the change in the policy, they had held out jobs to these people who were to be regularized. The court said you can't do that. But as rightly said, Manoj, as your Lordship, the Chief Justice pointed out, the constitutional bench judgment stares at us. I pointed out to your Lordships that para 39 of that judgment, 49, I beg your pardon. I rest my case. Obliged for the very patient hearing, my lord. I'm thanking your Lordships on behalf of Prakash, myself, and Mr. Manon.
Only one aspect may not reply.
You are not thanking us. They are thanking.
But
You should also
I
thank.
thought one aspect I'll bring to my lord's notice, but thank my lord.
Yes.
Very
Yes,
fair
yes.
to the court, not very fair to the. But one aspect, with your lordship's permission. What I stated by one of my senior friends, factually I made a wrong statement. That may not be correct. Kindly see page 78 of 525. What I have stated is, as sworn by the officer in the affidavit, it is not a statement made by me to say that it's factually incorrect. Kindly see, Marat, para J,
520.
525, page 78. But I should inform the court, Marat, since a statement has been made. Para J, apart from, if you're not 78 minutes. Apart from the non-registration of plot, because of the government's advice on the matter, it is important to note that 26 acres of land was never cleared by the government, and hence with the extended scope of allotment, the original allotment proposal has completely been modified, and it required the approval of the government before any kind of allotment could be done, and original is modified. But this statement is on oath by an officer of the government. That's it. But about the constitutional bench judgment also, right? Kindly consider not para 43 and 44. I've just seen the para 43 and 44 of the said judgment. But
What?
to the extent,
2023.
pardon?
2023.
Yes, ma'am.
Para.
Para 43 and 44. I'm deeply obliged, Manoj, for the patience hearing.
Mark everybody's plans. Arguments heard. Result. $30.
May I please?
Lordship, I'm appearing on behalf of respondent 1 to 3 in this matter, my lordship. On the last occasion, the appellants have filed a counter.
Objections.
3 more weeks to file a counter, my lord. Reply to the counter.
Forget about. What is
My lord,
count?
there's a personal difficulty for the clients to sign the reply, my lord.
That's
They're
it.
not currently in the country, my lordship.
DRDL land, my lord, that day, my lord, they have conducted the survey.
Madam, 18 years. Still you are interested that it should another be remain pending till another 18 year till you are designated by as senior advocate by this court, right?
No, my lordship, they're seriously.
What is this? I don't know what serious. See, 2005 you are seeking adjournment. Why? So this thing.
I filed, my lord, objections to the
Survey report.
Survey report, my lord, I filed the petition. They want to, my lord, counter that.
Tell us any justification for not arguing the matter and seeking adjournment. What is the justification?
File a reply to the counter which they have filed.
No, when they filed.
29 September, my lordship.
So today is what?
11th of October, my lordship, but the clients are not in the country, my lordship. We couldn't get their signatures or like get a meeting with them, my lordship. We'll be filing the reply definitely for the next occasion, my lordship.
Why don't you file a suit and prove that this was the land which was in existence? We don't know whether factual all this dispute we can adjudicate.
The survey report says that
What?
there is excess land. We are asking for land acquisition proceedings to be carried out for the excess land to be acquired, my lord.
Nineteen 65 is award.
They are saying that this some area, the applicants are in occupation, respondents, and therefore the survey it has been this.
But though there is no direction from the Honorable Court to conduct the survey, but the survey has been conducted. And on the survey also, it was not conducted in a free and fair manner, under coercive measures. But therefore, I have filed the objections.
The objection means what? In your absence, it has been done.
No, the last kindly see the interim direction passed by the Honorable Court in earlier. The directions from the Honorable Court, status quo obtaining as on today to be maintained by the parties. In the meantime, the government shall submit a report as to how much land they acquired and how much land actually they took position in the acquired land. But contrary to that, without any of authorization, they have proceeded with the survey. And initially, on survey, my notice is issued. I went there, but around more than 30% are there, and we are not permitted to participate in the survey also. And whatever the disputed land, that is outside the body. And the acquisition, the acquisition was held by virtue of award 11/5/1955.
They are saying that the accounting application application. Yes, disputed question. Always there's a direction. See here. Allowed to initiate proceeding.
The counter affidavit filed by the respondent number 2 and 3, additional counter affidavit in the petition number 10138 of 1992. And categorically said that the surveys have been demarcated 39/2 and 40/2. The survey is already conducted in the year 2000. So far, they have not neither raised objections nor challenged. In the presence of the survey,
So kindly grant to 3 weeks time, my lordship. As soon as the clients are back in town, we'll definitely file a reply. And
No, so I mean it depends on their travel schedule, right? This court is deprived, cannot adjudicate till they come back. Right?
they will definitely be back.
No, we don't know back or whatever. Fourth. Let's see what is this matter? 2005 appeal. Tell her. Tell her what.
In the notification, these lands are owned?
Yes.
Where is the notification?
Yes, notification no. I filed the award. Award in the objections recently have filed. Page number 11. Even the name of the petitioner is also not there. Where they have come they are claiming excess land. And demarcation also.
Where was the rate petition filed?
1992. Application is 78.
So they were waiting patiently till. So 14 years when every other remedy was time barred, then they thought of brilliant idea of filing a writ petition.
And everything is answered by the special deputy collector by a additional counter affidavit. In the number 11 and 12, my lord.
So, madam, what were you doing for 78 till 92? They must have gone abroad again. So after 14 years they landed, then they thought that, oh, there is a high court here, we should file a petition, and again went back. Huh? No, but like you understand, right? The belated claim after 14 years, supposing if they are in occupation, even assuming your version to be correct, at the most we can accept that everything is correct, that they are in unauthorized occupation of your land since 78, right? Why did you file a writ petition in 92? What is the explanation of not taking any action for 14 long years? In a writ petition, obviously this sort of a relief which is barred in law could not have been granted. Everything you had lost, even title, everything. If you had title also, let us assume you lost it because 12 years. If they are encroachers, so by adverse possession they had acquired title. Huh?
The same thing,
No, you will have to tell us that you have acted with reasonable dispatch without any this thing. What is the explanation? 78, forget survey report. 78, they are since 78, according to your own case, they are in possession of your land. Why did you, after 14 years? Tell us everything in your favor. Why we should entertain a claim which is barred by law? You lost the title to the land on lapse of 12 years of time. What, let them be abroad or India, doesn't make any difference. In Australia, North Pole, South Pole, doesn't make any difference, madam. No, you answer this. It doesn't depend on any counter or their being in anywhere in the world. That 78, they had taken possession to 1992. After 14 years, you filed the writ petition. What is the explanation? We will grant you time provided you satisfy us any prima facie reason that they were waiting or whatever happened. Somebody assured them that no.
They got in the case long enough to know what has happened in the
No, it is not a matter of personal knowledge. This has to come from record. Not a person that I was not even born in 1988. That is no ground. So you will say that I was not born in 98. So therefore I don't know anything. 88, I was not even born in 78. Right? Correct. You have been born after 78. So you can't say that I don't know anything. It pertains to prior to my coming to this planet. You can't say this. This has to come from the record, not personal knowledge. We are not asking you anything personal knowledge. We also don't know where is this land, what is it. So then, no. We will adjourn provided you tell us some explanation from the record. See, they may be anywhere. That does not depend. This question will stare at your face even today and after 3 weeks also. You cannot get away by saying that they have gone to Australia, so they will come after 4 weeks. But nothing. What happens? This has already happened. Related to body by respect to and disputed question of fact. Two things. Disputed question of fact cannot be adjudicated. Secondly, belated 14 years on your own showing. '81 you had given representation. That means you knew 11 years thereafter. What did you do? Even assuming that '81 you gave a representation. 22/12/81. This thing, 29/9/81. Thereafter also this petition has been filed in the year 92.
Lordship, the matter is posted tomorrow. Council will appear. Council, if the rate of pending will appear.
New Year, they don't want decision. Let them celebrate New Year in wherever they are. Come. Right, madam? We are also not in a hurry. We are not bothered. Right? The only thing is this is the level of cooperation which you assure the court that we will cooperate for early decision. We are equal partners in administration of justice. This is what it is. 2005 matter, you are seeking adjournment. The client will not tell you the legal position, right? The fact is that you knew about their unauthorized occupation in the year 1981. Despite that, you have filed the writ petition after 11 years. What client will tell you? Even if he comes from abroad, what he will tell you? You will have to prepare yourself and argue the case.
They have no right at all, because even according to the counter filed by the state government, they categorically,
Madam, we are trying day in and day out to finish these old cases, right? And this you want to keep it pending. What for? So whatever. What is the explanation? What basis the finding is recorded that they should initiate plan efficiency?
Matter is posted at least after 1 week by lordship can appear as filed inside about. Senior counsel will appear in this past.
Who is the senior counsel? This is unfair on the part of senior counsel also to send you in 2005 matter and expect this court to adjourn. Right? Who is the senior counsel? He should have come, no? He appeared before this court in.
last occasion he appeared.
Huh?
Last occasion he appeared.
Learned counsel for the appellant. an adjournment. We will not do it. Learned counsel for the petition. Monday, no? 16:10. 16:10.
Retrigger lodge.
2009 updates. There are no older cases, madam. Huh? No old cases of 2005. Maybe over. Find out. Find out how many cases of 2005 pending. 6, 7, 8.
But
The
common, this writ appeals have filed in the common judgments in both the writ petitions, my lord, writ petition 124 and 125.
Huh.
My lord, here, the main gist of the case is, my lord, that the respondent, my lord, has applied for a service connection, my lord, with a load of 1800 kilowatt. A small synopsis. And a judgment, my lord, which during the COVID, my lord, same issue was dealt by this honorable court, my lord, same circumstance. That also I have just passed on.
Covered?
Yeah, covered.
Is it covered?
Yes, covered to the extent of the principle they have covered, my lord, that's why I have to. My lord, if your lordship may see the synopsis, my lord, I may draw your lordship attention to it. Here, my lord, the respondent, my lord, the writ petitioner applied for, filed an application, my lord, to provide a ST service connection load of 1800 kilowatt. My lord, then first phase, my lord, to be released 800 kilowatt. Second phase to be released was 1000 kilowatts. Then my respondent entered the agreement on 22/5/22nd May 2005. My lord, these are the conditions of the agreement, my lord, which I have stated. Well, the clause 3 of the agreement regarding the maximum demand, here is agreement is filed at page 50, my lord, same clauses, my lord. We agree to take from the Central Power Distribution Company of AP Limited electric power for a maximum load not exceeding 1800 kVA in two phases. Phase 1, 800 kVA required immediately, and phase 2, 1000 kVA required within 3 months, which shall be taken to be our contracted demand for our exclusive use for the purpose above mentioned at our mills factory was situated survey number so and so. Clause 6 regarding commencement of the agreement to the extent. Date of coming into force of the agreement, we shall begin public take electric energy from the company under the condition of this contract within 3 months from the date of issue of intimation in writing to us by the officer of the Central Power Distribution Company. The supply of electric energy is available. The provision of this agreement shall be deemed to come into force from the date of commencement of supply energy or the date of expiry of 3 months notice above referred, which was earlier. Clause 2 and 9 of the agreement, obligation of the consumer to pay all charges levied by CPDB, the Central Power Distribution Company. From the date of the agreement comes into force, we shall be bound by and shall pay the CPDB AP Limited maximum demand charges, energy charges, surcharges, meter rents, and other charges, if any, in accordance with the tariffs applicable and the terms and conditions of supply prescribed by CPGR from time to time for a particular class of consumers. Then clause 11, monthly minimum charge shall pay minimum charges every month as prescribed in the prescribed tariff and terms and conditions of supply. Even if no electricity is consumed for any reason and whatsoever, also if the charges for electricity actually consumed are less than the minimum charges, the minimum charges shall be payable by us even if electricity is not consumed because supply has been disconnected by CPDC because of non-payment electricity charges will for other manufacturers for any validity.
Well, a power supply of 800 kV in the first phase was released on 16/9.
No, what is the issue?
Issue, my lord.
You are not reading just.
My lord, I'll submit. In this, my lord, first he has taken 800 kVA, my lord, it was released. Within 3 months from then, my lord, 1000 kVA has agreed to take. Then, my lord, they filed a letter, my lord, saying that they are not receiving a machinery which they have to receive from the third party to set up the industry. So they asked for extension of time. 3 months that was granted. Again, they asked for extension, 3 months it was granted. After that, my lord, again, my lord, they did kept quiet. So we released the other 1000 kVA. Now, my lord, as per the agreement, my lord, the agreement for the first 2 years, my lord, they cannot reduce the contracted demand of 1800 kVA. Because, my lord, once they enter into agreement with us, my lord, we place, my lord, we contact the generators, my lord, and place an order for this amount of energy, saying that we require this amount of, you please generate it. They generate that energy, my lord, which you have supplied to the consumer. If, my lord, the consumer does not, my lord, take this or does not utilize the power, my lord, we still have to pay to the generators. So the whole aspect for the first 2 years is, my lord, they cannot reduce the CMD. Because we have to take it from the, we have to, my lord, pay the generators. And generators do not accept, my lord, for reduction of the. On that ground, my lord, then, my lord, they applied for deration, my lord, of the power, saying that we don't need this much power. You reduce the power, my lord, stated. Then, my lord, they applied for termination of the agreement, which, my lord, is important, but at para 12, if your lordship may see, that I just read that, my lord, in the same synopsis, my lord, your lordship.
Is it covered by this?
Yes, my lord, there this honorable court discussed, my lord, this whole issue, my lord, your lordship may take, my lord. What has happened in this case, my lord?
What was under challenge in the writ petition? What has been done by single judge? That you have not told us.
That's what, my lord. Then, after these facts, my lord, I'll here, my lord, what has happened, my lord? They again applied for duration of power, saying that, my lord, within the period of 2 years, saying that, my lord, now because we are unable to get the machinery for so and so, we do not need this much power, you derate it to the minimum level. My lord, we rejected their condition and we claim, my lord, for the 2 years at the rate of 1800 kilowatts per month. And, my lord, they had about 27 lakhs, my lord, their consumption deposit was with us. We kept as deposit which every consumer has. We adjusted the 27 lakhs and then another 24,292 others. They said you pay this up. Questioning this, they have filed this writ petition. The Honorable Court, they raised a plea, my lord, under section 56 of the Contract Act, 56 of the Contract Act, my lord. The supervening impossibility has arisen because third party did not supply us the machinery, hence we could not set up the industry. So, my lord, we are not liable to, my lord, comply with the terms of the contract and they should refund this 24 lakhs to us. The Honorable Court, my lord, held, my lord, that's your lord. My lord, page 24, if your lordship may go, in the writ paper, appeal paper. If your lordship may take page 15, my lord, for once. I'll just page 15 of the writ appeal. 15, page 15. My lord, para 2 in the middle, my lord. I have given my honors consideration to respective submissions made by the learned counsel on other, peruse the impugned orders and other facts are much in dispute, my lord. That's the only aspect which needs to be examined with. Page 15, 15. The last second paragraph from bottom, and the facts are not much in dispute. That's the only aspect which needs to be examined is whether in the facts, circumstances of the case, a contract entered into between the parties was frustrated as per section 53 of the Contract Act, and thus the petitioner is not liable to pay the minimum consumption charges. Admitted the petitioner applied for 1800 kVA, my lord, which facts, my lord, which I have already placed before lordship, my lord. namely so and so, when the company was under, the electricity has to be supplied in a phase manner, and the next page, when the respondent sanctioned electricity load of CMN in two phases, the first phase of electricity was to be the load of 1800 and the second phase by 1000, which I have stated, my lord, in the, my lord, already in the synopsis which I have brought to your lordship notice. All these issues, then, my lord, finally, my lord, your lordship will say, page 24. My lord, coming to the facts of the case, my lord, I have noticed above, by reason of supervening the impossibility, an act agreed to be done becomes frustrated and attracts the provision of section 56 of the Indian Contract. From the very beginning, the petitioner has been asking for duration of CMD of 1000 K on the ground that the foreign collaborator has failed to fulfill its obligation. Thus, the petitioner was unable to secure required measures for revival of the security. Therefore, ultimately, the project could not take off, and whatever machinery available was shifted to Mumbai, and thus even the unit of the petitioner before it could be revived became sick. Hence, it cannot be said that there was no frustration of the contact between the parties. No doubt the frustration, well, this is important, but no doubt the frustration of contact is not on account of respondent, but unless and until a machinery was received by the petitioner, it could not have commenced the project, and these facts are not in dispute. Thus, the agreement has become an impossibility to perform on the part of the petitioner. Therefore, the doctrine of frustration is very much applicable to the case on hand. The petitioner cannot be asked to perform. Impossible. Firstly, the petitioner so and so, my lord, they have not used it 1000, my lord. Next paragraph, page 25, my lord. Under these circumstances, in the guise of the contract, the correspondent should not have charged for 2 years CMD against 1000 kVA, which was never utilized by the petitioner, and adjusted the same from secure deposit lying with them. Court undoubtedly has to examine the contract circumstance under which it was made. The chain circumstance has destroyed altogether the case of the adventure and underlying object. In view of the failure of the foreign collaborator to supply the crucial component of the machinery production of galvanized pipes, tubes, and projects not taken, and even 800 K not used, unless the machinery received, the petitioner could have utilized the second phase. Thus, the base of the contract was frustrated by the intrusion or occurrence of unexpected event. Change circumstances beyond what was contemplated by the time. Since the contract was frustrated, the court of the considered opinion that it was not proper on the part of the respondent to demand 1000 kVA from the petitioner for 2 years in the guise of 5.9.4 general terms and conditions, my lord, which I have extracted in the synopsis last. The action of the respondent is arbitrary, so and so. Therefore, the impugned order dated so and so is liable to set aside, and according said, then the respondent direct to refund the security deposit. We are asked to refund. Against this, we filed the present appeal. The matter which now we are referring to, which is covered with the lordship. This is the issue, during the COVID notification was issued under the Disaster Management Act to close the industry for certain period of time. So here, my lord, we raised bill on the HT consumers, high-tension consumers, my lord, for raising, my lord, demanding minimum amount, minimum bill per month, because it has to be 80% of the contracted CMD. We raised the bills as per the agreements, my lord, and general terms and conditions of subjects. My lord, they filed writ petitions, my lord. This honorable court, my lord, held. Well, on 56.2, it has become supervening impossibility. The contract could not be, my lord, going forward with, because, my lord, they were stopped from using the power, utilize the power because of, my lord, notification issued under the Disaster Management Act. And that was finding, my lord. Then they allowed the writ petition, and they held that the demands made by us are illegal. My lord, your lordship, take it. Page 13 of the judgment. Para 84. The repairs are allowed with the COVID-19 pandemic force measures. There is no force measure clause in the agreement. Section 32 of the Act, 87 does not. However, Section 50 of the Act operates a doctrine of frustration is applicable. Your lordship, into your lordship note, Section 56 of the Contract Act. 56 contract. If I may read the agreement
What
to
is
do.
the issue of, you tell us what is
My lord,
the
the entire issue in this case is, my lord, for the 2-year period, my lord, whatever 1800 kVA we are entitled to collect the charges because, my lord,
what has been held by division?
this honorable court, my lord, held, my lord, the 56(2) does not apply in this case.
Ah.
Then, and we are entitled to collect, my lord. My lord, at page 20, my lord, if your lordship may take. Page 20 of the judgment, what the honorable facts of this case reveal that large number of writ petitions have been filed by companies, partnerships, proprietary concerns who have obtained high tension service connection from the distribution company with a contracted maximum demand. The undisputed facts of the case make it very clear that on account of COVID-19, various orders have been issued by closing the industry. Well, next, my lord, the honorable court said under section 62 of the Electricity Act, my lord, we have to comply with the orders issued by ERC. Hence, we are entitled to collect these amounts. And they have dealt with the same, my lord, your lordship may take, my lord, page 25, my lord, page 25, para 22. Request an entry of the agreement with Apple and distribution company, class 7, 8, 9, and 10 of agreements read as follows, which I have read, my lord, in the synopsis. My lord, where I have played with your lordship, my lord, where we said, my lord, determination agreement, we shall be at liberty to determine the agreement given in writing 3 months notice expressing such interest at any time after a period of 2 years. If for any reasons we chose the 3 months to derate the terminal agreement before the period of minimum 2 years, the duration of termination will be done with effect from the date of expiry of 3 months notice period or expiry of the initial 2-year period, whichever is less. In this case, my lord, within about 8 months, my lord, from the 2005 when they actually entered an agreement, my lord, they applied for duration. Then, my lord, we said it has to be done only after 2 years, my lord. In the synopsis, we have clearly stated it can be done only after 2 years. And, my lord, this you are liable to pay so and so dues. And hence, my lord, the 27 lakhs, my lord, the deposit which is with us will be adjusted towards the dues payable by, and the balance amount of about 24,000 we demand. The honorable court, my lord, they held, my lord, that 56(2) supervisory impossibility, my lord, comes into effect. Hence, we have to refund the amount.
These dues are minimum charges or have they consumed the power?
Where, my lord, these are not, they consumed only about 800 kV, they did not consume the other 1000 kV. Even in these cases also, my lord, this was, which are.
What is your demand? Is it minimum charges which they have?
Yeah, minimum is 80% of. We cannot, if it 1800, we don't claim the 1800. Minimum charges is 80% of the contracted maximum demand. Those are only we have claimed then also and now also in this.
What is the period of contract?
Well, minimum first, well, it is unending. Contract, well, once they enter now, it's the unending. The first 2 years of the contract, well, first 2 years of the contract
can't be unending. Someday you will die. So everything will come to an end.
Thing is,
cannot be unending.
I am saying is once they enter into a contract once, well, for the first 2 years, they cannot derate. I'll read the.
So in case of closure of the company, if they are unable to run the company,
then 3 months.
Is there any provision to terminate,
Yes,
giving notice?
Yes, ma'am. It is there in the agreement.
No, where do we get in the agreement?
Synopsis, my lord.
It's a page synopsis.
Agreement, my lord. 5.9.4 of general terms and conditions of supply, my lord, your lordship.
With your lordship's kindly, my lords, your lordship will find it at page 51, my lords. With termination.
No, your agreement is at page 44. That is the agreement.
No, that is type 15.
No, this is clear. Is this the agreement which you are relying?
Yes, my lord. That's what.
Where do we get that clause?
Yes.
Clause is at page 50, my lords. Page 50, the lordship sees 7. Period of agreement is for 5 years.
Determination of the agreement, my lord. Page 58. Clause 8.
5 years.
we shall be at liberty to determine the contract by giving in writing 3 months notice expressing such intention at any time of the period of 2 years. We agree that the Central Power Distribution Company of AP Limited may terminate the contract at any time, giving 1 month notice if we violate the terms of this agreement or the terms and conditions of supply notified by Central Power Distribution Company Limited from time to time, or the provisions of any law touching this agreement, including the LI supply Act 1948 and 1910. This agreement shall remain in force until it is terminated above, in computing the period of 5 years and 2 years referred to above the periods which the annual minimum guarantee has or shall be excluded. My lord, even within 2 years, my lord, if they apply, my lord, even if they within 2 years, even if they apply, they can apply for duration, but it will come into effect only after completion of 2 year period. For agreement, because my lord.
No, what is the period of demand?
Demand, my lord, for 2 years. Already for about 8 months they paid 800 kVA. They paid, my lord. They paid till that time, my lord. First 800 kVA it was there. After that 1000 kVA or 1800 kVA. From the time immediately when the 1800 kVA was demanded, my lord, they supplied for duration, saying that company is not able to run. We are not even able to actually establish. So, my lord, you bear it. Then, my lord, we gave a notice saying that that cannot be only after 2 years. It will be done from so and so date. And, my lord, what we have done is, my lord, for the 2 year period, we have demanded the amounts. I said, this is the amount due from you, and you are having secure deposit of 27 lakhs with us, and we have adjusted that amount. And after that, about 24,000 was due. You please pay that amount. We give them. Then the final inspection. Under saying that, my lord, under section 56 of the the Contract Act, my lord, a supervening impossible, we cannot demand the amounts.
I thought that synopsis is right, so. It's not a place for section 56.
My lord, if your lordship may remember this judgment, page 31, man.
No, please show the findings. Where do we get that, the findings? Whether section 56 is applicable or not?
In the writ
judgment, what?
Yes.
They're referring to section 65 and 108.
All that, my lord, that is powers under Act of the ERC that they have discussed, my lord. What they have stated, my lord, if your lordship may see, under section 62, my lord, the ERC, my lord, if your lordship at page 22, section 62 Electricity Act.
No, in your memo, you say at that the Retapil 120 and batch.
Yes.
In that, this honorable court held section 56 of the contract is no application.
I have no application to the facts of the
This
present.
is what you are referring, this judgment.
Yes, ma'am.
Where do we get that in the findings?
Yes, your lordship. My lord, if your lordship may draw your
Findings are at para 34 and 35.
Page 25, my lord, the same clauses in the agreement which, my lord, which are actually subject matter issue in the present writ petition have been considered at page 25.
That's why I'm reading facts.
But page 25, the same agreement clauses are considered. Page 27, if your lordship may see. Para 23, man. The aforesaid agreement, your lordship, para 23 page 20, the aforesaid which has been executed between the parties makes it very clear that the writ petitioner have undertaken to pay maximum demand charges, energy charges in accordance with the tariffs applicable and GTC as general terms and conditions prescribed by the company from time to time. Clause 10 makes it very clear that the minimum monthly charges are payable even if electricity is not given and the same is in existence. These are the minimum monthly charges what we have defined. It's true that on account of pandemic, lockdown was imposed by state of Telangana and disaster it was extended from time to time, which reads as follows. Then page 31, para 27. In the considered opinion of this court, the judgment is distinct on facts. As in the present case, the appellant was constantly, regularly supplying electricity to the writ petitioners. Here, there is no failure on our part. But discharge its liability by paying statutory dues to the transmission companies and generating companies, and therefore the order passed by learners in declaring the action of the appellant distribution company levying and demanding minimum charges both on maximum demand and energy charges as illegal is certainly bad in law. The contract executed between the parties makes it very clear that the writ petitioner are required to pay minimum charges and energy charges, and therefore there is no such relief could have been granted except jurisdiction article. Learned Singh has placed heavy reliance on judgment of South India spinners, and the matter has allowed the writ petition by referring to the principle laid down by the Honorable Supreme Court. In short, nutshell, the writ petitioner before the Learned Singh contended that on account of force measures situation created by COVID-19 lockdown imposed by God, the maximum demand charge are arbitrary, unjust, and same shall be recovered and should not be same should be recorded equitable and pro rata basis in respect of law. That's why what they said equitable pro rata, they have used only for half a month. In the notification, they said only we are liable to pay on pro rata basis for 15 days. Even that has been rejected. Also contend that the writ petitioner compelled to close down the industry, the TSP will not enter and collect maximum charges and the GTC and ought to have considered the working and non-working period of the writ petition and bill according to the learned single allowed the learned single judge held that COVID-19 has been recognized by Government of India force measure by its office date. Accordingly, Section 56 of the Contract Act will apply in the case. As already stated earlier, the learned single has also placed heavy reliance on the judgment of Madras High Court. In this Madras High Court, what ERC itself directed you charge lesser amount for the COVID for that ERC. But still, when the power companies were imposing, they went to court. The Honorable Court said, the Section 62 of the Electricity Act, because ERC has got the power, they have given certain concession, you are bound to obey. And you only make demand the amounts as per the consider opinion of the court, the learned single heard in law by granting relief to the writ petitioner. The learned single has observed that the contract question do not contain force majeure. Having observed so in para 43 of the impugn of the learned single held that 32 of the contract will apply only when force majeure clause is there and the absence of the same section 57 contract. In fact, there is a categorical finding in para 84 impugned on section 30 of contract does not apply to the fact since there is no force majeure. And the doctrine of frustration will apply. Consider opinion of this court, the doctrine of frustration cannot be invoked to direct to levy charges for pro rata in assess section 50 of contract contempt an agreement to an void or becomes possible to perform that. In section 50 of the impugned order, the learned reliance of where it has held the contract may avoid if the superseded circumstances they have dealt with. Para 32, the last. Consider opinion in any event the payment of inputs are not period to be impossible. The writ petitioner content that unreasonable actions are not contemplated under section 50 of the contract, and therefore there is no provision, has no application in the past. Okay, unless a contract word for occurrence force measure event and the manner in which the charges would be levied, such event occurs, the single judge ought held that the action is illegal. The action within the contractual right to levy charges. Section 50 would not come to the aid of the writ petitioner as the said provision contemplates voiding of a contract in case of performance impossible due to unforeseen circumstances. Single judge has placed heavy reliance. Charges were governed by statutory, namely regular 6
What is the reading?
Where are you reading?
Page 35 of the judgment.
Internal page?
Page 34, my lord, if your lordship. Or should I, my lord? If your lordship, page 33, my lord, the last paragraph.
You have not told us what is the issue involved in this writ appeal. What was the division bench? What has the division bench dealt with? Just reading like for yourself. Right, you should see to it whether the court is with you. You have not told us the facts clearly. Read, started with this synopsis, read some clauses of the agreement and then stopped. Then we asked some question. Then like, so this is what I mean. So we are trying to, because we have to write judgment. I have at least understood the facts from the order passed by learned single judge. And I have understood what the single judge has held in this appeal. I have now understood that the section 56 of this thing contract act applies, and in respect of the electricity which was not even utilized by the petitioner, you could not have charged them and could not consequently have adjusted the amount of security deposit. This is the ratio. What is this judgment? Now we are trying to find out what is the judgment. Please permit us. You are reading from somewhere. What can be done, Mr.?
The lordships. With your lordships kind leave, my lords. This judgment, my lords, the lordship sees, my lords, para 32, my lords. The judgment relied by my learned.
No, if you know, then tell us, otherwise we will go through it. What is the issue involved in this writ petition, writ appeal, and what is the division bench? He has passed on, and it is our job to find out what is it.
My lord, sorry, my lord, I'll submit, my lord, in this case.
So,
The lordship permit, I'll explain.
no, you, if you know something, then tell us. Otherwise, we will find it out. Don't. Better that we find out.
No, para 32 answers the query, my lord.
Which para 32?
Para 32 of the citation which is being relied, my lord. Where the lordship sees, my lord, the learned single judge's order is on doctrine of frustration. If your lordship sees the para 32, my lord, here there is no impossibility. Impossibility is the primary ingredient for the doctrine of frustration. If your lordship closely sees para 32.
No, Mr. See, the only thing which we are required to examine is that the ingredients were not supplied to you by some third party.
Yes.
Right? Therefore, you could not set up the plant and machinery and could not utilize the 1 minute. You could not utilize the electricity. So, but the learned single judge has said that the frustration of contract is not on account of respondents, even though it may be account of some act of somebody else who is not a party to the contract, whether the doctrine of frustration of contract will be attracted. You tell us this.
Yes, as per plain reading of 56 minutes, any event which occurs minutes, which is beyond the control of the parties minutes, that is where the doctrine of frustration attracts. It may not be the.
It's very easy to give a lecture like we are not law students, right? Like case law. They're like just not like it may be like this, may not be like this. Have you examined this?
Yes.
Yes. So tell us. That's what we are asking.
May I read minutes 56 minutes?
So illustrations are interesting, right? A and B. Yeah. C, contract.
Yeah, see.
We will have to see the this thing. See, one thing depends upon whether section 56 applies. If it applies, then done. But the only thing is that the reports of finding here that no doubt not any. So frustration is not on their account. Somebody else's account, they will be intimated. 61. It is believed 63 and 66. Instant of the which will be it can take international simply release. When they have this extension, without considering without released in 66 bodies. Suppose they lost it, then the contract would be resolved. This thing is single but the rely on frustrations and they breaking like reading stuff like they could not set up the factory, they could not engine power. This agreement is frustrated and the state of the needs to be that clause of making payment. No. Where is the agreement?
Page 50, man. Page 50.
Para 3 is their maximum demand, Mr. Chairman.
No, para 11, monthly minimum charges. See, Mr. Para 11.
Yes.
9, 10, 11.
Then para 9 also.
Monthly minimum charges. So, how do you get out of this?
Talking, if I may. There's a specified, they agreed for the clause, Millards, but if there's an impossibility or a condition, Millard, then doctrine of frustration comes.
No. This all, Mr. Read clause 11. That means you have not read it.
Clause 11, Millards.
Ah.
We shall pay monthly charges every month as prescribed in the prescribed tariff and terms and conditions of supply, even if no electricity is consumed for any reason whatsoever, and also if the charges for electricity actually consumed are less than the minimum charges.
So, you have agreed to pay minimum charges even in the event of no consumption. Then,
yes, Millards. As per
what? Then? You have to pay. You cannot get away.
Para 9 also, Millards, deals with obligation to pay all.
Yes, Millards.
So then under the agreement, I mean, it's a contract between the parties. Contract provides for the consequences. What is it?
Yes. There is a specified clause, Millards, as per which I agreed, Millards, I have to pay the minimum charges. Millards.
Then?
Minimum charge. But Millards, Lordship,
This is at this adjustment of security amount is towards minimum charges.
yes. And there are two parts to this, Millards. One, also they have charged me for the 1000 kVA, Millards, where I have been back and forth writing representation saying that my machinery is stuck. The industry couldn't take off because I purchased the sick industry, Millards.
No, Mr. Whatever it is, till termination of the agreement, you are liable to pay till it is, even if you don't consume, how do you, please understand the query, clause 11.
Yes, my lords. 11 is an obstacle. 11 is an obstacle, my lords. 11.
Obstacle which unsurmountable obstacle.
Yes. No. With great respect, my lords, as per plain reading of 56, my lords.
Plain reading?
Of 56, my lords, section 56 of the Contract Act.
No, merely because single judge has said you are just giving a lecture on 56, right? Any case law. That clause section 56 will apply only to also in such a situation.
If your lordship sees, my lords, at page number 18, my lords, where the learned single judge has for a moment, my lords, if your lordship appreciates.
No, Mr. If you are ready, I mean, then only just don't, for the sake of, show us a case law that in a contract covered by clause 11 also section 56 applies. What is written in section 56 that we know.
If your lordship,
you have also read it in.
Yes, if your lordship if your lordship for a moment sees page 17, my lords, of the learned single judge's order, my lords, where my lords, learned single judge has relied on the citation, my lords, where for a moment. Page 17, my lords. If your lordship sees, my lords, the case law, my lords, in Satyabrata Ghosh versus Munigrima, Bangur and Co. and another, my lords. If your lordship sees, my lords, the first paragraph, my lords. The word impossible has not been used in the sense of physical or literal impossibility. The performance of an act may not.
No, Mister. If you have not foreseen a particular circumstance, then that the doctrine of this thing frustration will apply.
Yes.
If you have agreed that even if I don't consume electricity, I will pay minimum charges, that is a situation you have expressly agreed to. Such a case, doctrine of frustration will not apply.
Here. 3 lines.
Right. It can only apply to an unforeseen circumstance.
Yes, if your lordship sees, my lord, the same judgment, my lord, if your lordship sees the
Sense of physical or literal impossibility.
Yes. If your lordship sees, my lord, little.
Hey, Mister, don't just like reading this paragraph like he was reading.
No.
You also read from here. Contention of respondent is. You read till last page.
No.
Till he was reading.
Only 3 lines, but it's saying.
Don't feel inspired by him. We have already told him. He has not done his job. Don't feel inspired by him and start reading the way he was reading.
Because
didn't tell us anything.
We have
found out, 1 minute. We have found out what is the case. He did not help us in any way and tried to confuse us as much as possible by giving us a judgment without telling us what is the ratio. We are not going to refer to it.
In the same judgment, my lord,
if you don't understand, we can't help it, right? Yes. Wow.
Yes, ma'am. It can very well be said that the promiser finds it impossible to do the act which he promised to do.
No, nothing. Nobody is finding you. Clause 11, you have read it just now.
Yes, my lord. Clause 11, my lords, I promised, my lords. My lords, I
promised that I will not consume any electricity and still pay the charges. That is the promise you have given.
Yes, even though
How can you complain now?
My lords, clause 11, my lord.
He doesn't understand what to do. Huh? You argue whatever. Yes.
In clause 11, my lords, I made a promise, my lords, even though I do not consume electricity, my lords, I will pay the charges. That's what I promised, my lords. If your lordship sees, my lords,
you cannot get away out of that promise merely by saying relying on 56. That's what we are trying to tell you.
Yes, with great respect, my lords, I let
Section 56 will obviously apply to such circumstances which is unforeseen by you.
Yes.
And it becomes impossible. You have provided that even if I don't consume electricity, I will pay charges. So what is the Impossibility to act, nothing.
The impossibility, my lord, the industry couldn't take off because the machinery was not used, which was not anticipated. That, my lord, in this judgment, my lord, if your lordship sees, my lord, so
Please read clause again, 11. Last 3 lines.
the minimum charges shall also be paid by us even if electricity is not consumed because supply has been disconnected by CPDC of AP Limited because of non-payment of electricity charges, pilferage or other malpractice or any other valid reason.
Yes, for any other valid reason means it's inclusive. Even though if your the machinery which you have ordered is not received.
Yes, Lord.
This is enough for any valid reason.
And see this
Can you make any other?
Come to page 21. Internal page 14 of the order passed by learned single judge. Further, Central Bank of India, you have read. Come to page 14. See, law excuses further where contract is silent as to position in the event of performance. Second paragraph, 14.
The law excuses further.
Read.
The law excuses further performance under doctrine of frustration where the contract is silent as to the position of the parties in the event of performance becoming literally impossible or only possible in a very different
Law, this thing contract is silent. In your case, it is not silent. Expressly provides that in the event of non-supply also, you will pay. So therefore, this case law itself, the doctrine of this thing does not apply frustration. Got it, mister? You are a young person. That's why we are trying to tell you what is not. We are not sitting here to convince you. Don't. Yes. Yes, madam. This intra-court appeal arises from an order dated